My lord, I have complied the defects, my lord, by filing the
Mr.
legible
Das,
copies.
the voice is not coming.
My lord,
pin करके बड़ा कर दियंतु.
my lord, am I audible, my lord?
Now it is all.
My lord, I have complied the defects by filing legible copies and also the page 11, which was the missing page, and this may be accepted, my lord. And my lord, before the deputy registrar, I have complied it, my lord.
The Das Learned Counsel appearing for the petitioner submits, he has in the meantime removed the defects pointed out by staff reporter. Office to verify, office to verify, and in the event there is no further defect, to list the matter for press admission.
My lord, matter will be called 10 days after, my lord.
For admission, item number 2.
Item 2, my lord. In fact, there is a noting that. In fact, there is a noting.
Appliances are strictly in terms of the briefing already. Yes, item 2.
Milord. In fact, the order of GRF Annexure 8 series that is under challenge.
Just audible on.
That is under challenge. The Annexure
What
8
is
series.
under challenge?
Annexure 8 series, the order of GRF.
Order of the GRF.
Milord, I am
Annexure?
confining my prayer to my second prayer of the writ petition. I filed a memo to that.
Second prayer of the writ petition.
Milord. And the order of the GRF, so far the serial number 2, the majority members view.
So come to GRF order.
Milord, that is
Annexure 8.
Annexure 8 series, page 31, starting from page 31. GRF holds
page 31.
Starting from page 31, and the operating part is that page 33.
Yes.
GRF hold that the OP2 is liable to pay the.
Come to direction now.
Direction. The respondent is directed to allow power supply to the complainant observing all utility formalities and recover.
There you can't have any objection.
No, I will not.
Okay, then petitioner must clear all areas.
To subsequent after revision. That part only I am challenging. The petitioner must clear all areas at the time of revision. Fact that there is no defect in the meter. This is the area outstanding of previous consumer. There is no dispute at all over the computation of the area outstanding. However, GRF has the passed the order. After revision, he will pay that. Only that part I have challenged. Otherwise, I have not.
Then how are you prejudiced?
After revision, because the power supply will be provided only after he clears the area outstanding. That was our
He is a new consumer or he is a continuing consumer?
That is a new consumer.
New consumer, then how, where is the agreement? Shifting the liability of the earlier consumer.
That the power supply is provided to one Raghavendra Metallics. One Raghavendra Metallics, the power supply is provided.
X was provided.
It was put to auction. He is the subsequent purchaser.
So there is a fresh agreement or not?
Only
no, with the consumer fresh agreement or not?
So
from the agreement that the burden of the liability has been shifted to this consumer.
Only the clear area outstanding clear.
Please don't.
Thereafter the agreement.
Don't argue evasive. These are all live streaming. Please don't argue evasive. There must be a burden with him through an agreement entered into between the parties, and there must be a discharge accordingly. So therefore, the burden lies with him.
My submission, the agreement.
No, don't make submission. please come to your response before the GRF in that regard and the condition in the agreement.
No, agreement ହେଇନି. There is no agreement.
Sorry, then
There is
you have
no
succumbed.
agreement.
You have succumbed.
Agreement only executed after the clearance of the area outstanding and power supply will be provided.
So when have you communicated him that there is a, and power supply was provided subject to clearance of area?
Miller,
Where have you put
I
that
have
condition?
stated in my objection, your lordship.
No, any correspondence with
Yes,
me?
yes, correspondence there.
While giving power supply, you must have a correspondence with him.
Miller,
And you must make it clear, the new consumer, that yes, there is a outstanding and burden lies on you.
Annexure 5, Miller, page 21.
And it's a 5 page.
21. May I read, lordship?
When the power was supplied,
Power supply has not been provided.
hmm?
Power supply has not been provided to the new consumer. The auction purchaser, the power supply has not provided because of the area outstanding was pending. Because of that reason, he moved to the GRF.
Read Annexure 5.
Miller. Sir, with reference to the letters under reference, this is to intimate you that an area amount of rupees 79 lakhs 30,524 has not been realized towards the area dues of Messrs. Raghavendra Metallics Private Limited at the same khata, such and such, at Madikudar, at which you have applied for institute. Therefore, the permission for new supply, new electric connection at the same premises may be given only after payment of that amount in view of the clause 10(6) of OERC condition supply.
No, why are you not chasing the other man? Somebody is in area of 79 lakhs. You allow him to quit.
No, that
You allow him to run away. Why this burden will be shifted to the new consumer?
that is the law provides. So this
Okay,
recent
then let us
judgment,
see the law.
the recent judgment of the Supreme Court, your lordship.
It's not a property the earlier consumer transferring.
Yes.
It's a property he is purchasing by way of auction. Therefore, the auction conditions must prevail.
Miller,
Lordship, the ratio, same ratio is already decided by this one. The
recent
ratio
judgment, your lordship.
is
Achwa.
Lordship.
It's a previous liability.
Lordship.
So law is already settled. If
Settled.
it is a previous liability, they have to chase that man, they have to recover.
Raghunath paper mills case,
He has
this
to clear. That is the judgment, Supreme Court, lordship. I am supplying judgment. Recent judgment 2000
What are you extending?
Telangana state.
What are you extending?
The judgment of apex court, your lordship.
No.
That hold that he is liable to pay the previous outstanding. Your lordship kindly with the para.
Mr. Tripathi, you are conscious. Data copy details.
Paragraph 15.
No, you are conscious. This is a judgment purchase on auction.
Miller.
It's a judgment
Yes,
purchase on auction.
Miller. This
Yes.
is also same.
Before that, first come to the provision.
Miller.
Where the provision says the new line will be provided.
Miller,
subject
Miller.
to-
I have quoted in my. So far the finding of the Lawrence GRF.
No,
with regard
don't
to-
go to, let us see legal provision. If legal provision is there, that closes
Miller.
the case.
I have quoted page 4.
Page 4,
Miller. Page 4.
clause 10.6.
10.2 and 10.6.
Yes. Accordingly,
That amendment was came into force in 2010.
2000,
10.
this amendment came in 2010.
Miller. The OERC code 2004, that amendment, I have annexed the annexure 1, that
Okay.
amendment. Where the
The
applicant has purchased.
power supply was claimed when?
Power supply was claimed on 2015.
Huh?
10/11/2015, my lord.
10/11/2015.
15. Subsequent
Lordship.
after.
Yes. Accordingly,
Where applicant has purchased existing property.
just 1 minute. Yes, now let us see
The amendment provision.
legal provision.
Miller.
Hmm.
The page for yours, clause 10.2 and 10.6, where applicant has purchased existing property and the connection is laying disconnected, it shall be duty of the applicant to verify that previous owner has paid all dues to the licensee and has obtained no due certificate from the licensee. In case no due certificate is not obtained by the previous owner, the applicant before purchase of the property may approach to the engineer of the licensee for a no due certificate. The engineer shall acknowledge the receipt of such requests and shall either intimate in writing outstanding dues, if any, on the premises or issue no due certificate within 1 month from the date of application. In case the licensee does not intimate outstanding dues or issue no due
No,
certificate.
this purchase doesn't include auction purchase.
Miller,
No, this is purchase, this is a purchase directly from the owner. This is not a auction purchase. So therefore, this provision will not cover or govern the auction purchases. So let us see, have you even attempted to find what is the restriction in the auction condition?
yes.
So
He is
where
to
is that
pay.
auction?
That is as is where is basis.
Where is the auction notice?
Miller, your lordship, I am giving you lordships. In fact, they have not challenged the same before.
No,
to the GRA.
forget that. What they have challenged, they have
And I
not
am
challenged.
supplying
It
yours.
is your case.
Miller,
So where is the auction condition?
your lordship, I am supplying.
Because you are showing a decision.
Miller, I am supplying.
You are showing a decision
Miller.
where that was a condition
As
in
is
the
where is
auction
basis.
purchase.
Miller.
So therefore, let us see where have you taken your stand in the response
Miller.
before the GRF that there is such a auction condition.
Miller.
Yes, sir. Give another copy. Give
I
another.
have, in fact,
Dita copy stapling
I have ভুল রেখে টাপসটা তুলে এসেছি।
stapling chal. Hata phone jao. Hata photo photo. Ye card mein nahi. Yes, come to the agreement condition.
No, that is the auction notice.
Auction notice.
That is auction.
Yes. Auction notice कोठी अच्छी देखा तो अपन auction notice टा जीवा ठीक अच्छी. This is the auction notice. Come to your response
Miller.
before the GRF that you have relied on such condition.
No, we have stated that because of it has put to
Just
auction.
one. Where are you reading?
Your lordship.
Where are you reading?
Miller, the page 26, annexure 7.
Your objection is annexure 7.
Miller,
So which para you are reading?
paragraph B, 2B,
Paragraph
2B,
2-3.
2B, Miller, B.
2B.
Miller.
Yes.
That while the matter stood thus, due to
No,
non-payment of
you first understand our query.
Miller, that auction, so far auction.
No,
question is concerned.
auction condition must be there loading the area factor on him.
No, that only we say that there is a auction notice
No,
on the
therefore,
basis of auction.
sorry, you have not taken such a stand even, therefore decision doesn't apply.
Only put auction.
No, you can't improve here. We are making it clear for last 1.5 months. You must be doubly sure on your facts. Then place a reliance. You are placing a reliance, wrong reliance.
No, that is,
It doesn't come to help you. Mr. Tripathi, be careful. This is all live streaming.
Miller.
So hereafter, if you repeat and place a wrong judgment, we will imposing cost. We will be imposing cost on you because you are wasting time. Your time may not be felt to have been wasted, but you are wasting our time.
No, that has been put in auction.
So you have not taken this condition.
The
You have not
condition,
taken.
Miller,
Yes, absolutely.
he has moved.
Fundamental. It is fundamental, brother. Subject to another clause where the authorized officer carrying out auction observed himself the liability is absolutely, it is fundamental.
Milord, he has moved to the GRF, Milord.
Huh?
Milord, the OP2 had moved to the GRF.
Absolutely, you have a responsibility there
Milord,
by way of objection.
Can the,
Sir, here is a clause contained in the auction notice. Auction notice is the clause contained nahi. You find out. Listen, Mr. Tripathi, we don't block you from recovering. Question is recovery from A or B.
Milord.
B forget.
No, so far the recovery is concerned, your lordship.
Yes, that's and the method available to you.
Milord.
You go and recover.
So far recovery is
No,
concerned. I have
don't
not
trouble
challenged.
the courts on all your grievances. You don't see, you have simply disconnected, maybe monthly earning करिबा आरंभ कले, आपण चुपचाप बसी गले 85 लाख टंकार आउटस्टैंडिंग को घरे थोई दी. As if it's a liability on the consumer. What action you have taken against your officers?
No, we have
Why have you not proceeded for recovery?
recovery, Milord, so far.
Why have you not proceeded for recovery?
So far OPDR is concerned, is where we, the private licensee, it is not coming under OPDR.
Then civil suit available nahi.
Civil suit is there.
Agreement cannot be enforced through a civil.
Your lordship, allow me for a moment. So far my so far the liability is concerned, GRF has categorically held that he is liable.
Forget that.
I
Forget
am
that.
not
There's no
challenging
liability at all. There's no liability at all. Because auction condition is absolutely silent. Absolutely. You find out your ways. Then you withdraw.
Confining my
You
prayer.
withdraw. Yes, if you are satisfied with that observation of the GRF, you find out the remedy.
Observation is there. So far the revision.
So what do you want? A negative order, or you will pursue dependent on that finding?
Not pressed, your lordship. Not pressed.
Yes, in the course of hearing, finding there is absolutely no clause loading the liability on the fresh consumer. But however, for the taking support of the observations in favor of the licensee with regard to outstanding existing, the Tripathi Learned Counsel for the petitioner seeks withdrawal of the writ application to find out other remedies available for. So far it relates to recovery is concerned.
Lordship,
Permitted to be dismissed, but however, with the liberty. Please advise your clients accordingly. आपण society को burden करूचंती, court को burden करूचंती unnecessarily, and as rightly pointed out by the last judgment of the Supreme Court, yesterday my learned brother was pointing out that decision. Be careful. Have you read through that judgment?
That judgment is.
No, you are not reading even. Since yesterday, my brother pointed out that judgment.
Lordship, I may be pardoned, but regarding my connection of electricity.
They have not challenged.
You go for penalty, you go for damage.
That's-
Who prevents you? You have not come for enforcement. Ombudsman is also there for enforcement.
Obliged.
Please limit your submissions.
Lordship,
तो आमे आउ ये स्टेज रे नाही जे आमे एठी बसी मानसांक करिबा
Lordship.
चले नउतले कोठी चले जाउतला चलुतला बट इपा लाइव स्ट्रीमिंग हलानी दुनिया वकील बसी देखुतबे दुनिया महकिल बसी देखुतले कोर्ट रो कोन परफॉर्मेंस लॉयर रो कोन परफॉर्मेंस therefore let us be careful hereafter our decision आपण एनिकी जदी देबे wrong decision.
That is not wrong, that is.
It is absolutely wrong. You have not gone through the judgment. There, in the agreement, there was a condition, auction notice, there was a condition contained.
As is where is.
Clause 26, yes.
That is also there. The
No,
agreement also, the
sorry,
option
sorry.
notice also says.
Para 3 Padontu.
Milord.
My lord has given you sufficient hint. Basically, you cited a decision in his favor. So that is how the judgment, somehow the good sense prevailed and I withdrew it. But because that judgment helps him in saying that I am not liable.
And
But
we,
he did not challenge.
And we don't release, Mr. Tripathi, we don't release. Why you
I
sit
also,
over
my lord, I
85
also
lakhs,
relied one. good judgment.
85 lakhs outstanding, uncovered. सेटा आपण कोन देखौछन जानिछन जो आपनकर एनुअल आसुनी जेतोले रेज होची इलेक्ट्रिसिटी बिल ओटा कोन
That tariff.
टैरिफ के एनहांसमेंट रे बसचंदी
एवढा देखौछन.
सेतोले आपण थोई दउचंदी जे हमर अनरिकवर्ड एरिया दिस मच
नहीं नहीं, हमें सेटा देखो जो loss of transfer.
लॉस
GMR
देखौचंदी
Nine
GMR Padontu.
Yes, the line
Because
loss.
that decision was cited by my lord. He asked me that have you gone through that?
हां
So it has culled out earlier decisions.
Empty
But
85,
this
85
part has been specifically taken note of by the Honorable Supreme Court.
Two
That what is
crore.
happening.
2 crore, 5 crore, 8 crore. So you are in deficit by some 1,000 crores. Then you show that
ଆପଣଙ୍କ
the loss.
transmission loss ଏବେ କେତେ ଚାଲିଛି? Transformer ନୁହଁ ଆପଣ transformer
Transmission loss.
କେତେ 60%?
50% loss ରେ ଚାଲିଛି company.
Just
Transmission loss.
imagine ଆପଣ
Unrecovered.
transmission loss 50%, you are charging it from 50% who are consuming. So added to that arrears, litigation cost.
We are
You will leave
unnecessarily
that
burdened.
GMR.
Every consumer is unnecessarily burdened. Every consumer. ଆସିବ ଦିନ ଆସିବ ପାଖେଇ ଗଲାଣି ଆପଣଙ୍କୁ ବର୍ବାଦ କରି ଦିଆଯିବ. You don't deserve to continue with this system.
Item 3,
Yes, sir. Nobody is present to pursue the litigation. Dismiss for non-prosecution.
item 4,
Yes, item
I'm
4.
for the opposite party, my lord.
এটারে,
He's for petitioner. You are on behalf of Mr. Rath.
No, no, my lord, item 4.
he is
Item
there.
3 for,
P.
I am the appeal.
এটা Mr. Nath ଙ୍କ ନାଁଟା UP ପାଇଁ ଲେଖିବ. It is taken note of. Next.
Please, your lordship, item 4.
Yes, item 4.
My lord, on behalf of Mr. Lalitandu Misra, my lord, in this case, the opposite parties are electricity department. In the meantime, Mr. Misra started appearing for the electricity department. So he will not appear in this case.
So nobody is appearing, what we can do?
Kindly allow some time.
ଆପଣ intimate କରିଛନ୍ତି କି petitioner କୁ ଆପଣ ସେଟା ଜଣେଇବେ ନା ସେଟା ତ court order ରେ ହବନି. You have to intimate the
My lord,
petitioner.
in the meantime, I will
We
take
provide
instruction
you
from
1 week
our
time.
client and
We
he will
provide
engage some
you 1
other
week
lawyers.
time. We provide you 1 week time as a matter of last chance.
My
If
lord,
he comes all right, if there is no fresh appearance, the matter will be dismissed automatically. Today you are not knowing that
kindly keep
there
it
is
to
a
after
change.
vacation, my lord.
No, sorry, 2017 ର matter pending ଅଛି. Is on the footing that in the meantime, Sri Lalitendu Misra has started appearing. He has been engaged for licenses. Sri Lalitendu Misra has the difficulty in appearing for the petitioner hearing. It's a matter pending since 2017. Okay, there should have been earlier step in this regard. Be that as it may, keeping in view the request made herein. This court grants 1 week time as a matter of last chance for replacement of the counsel on behalf of the petitioner. Appropriate vokalatnama with fresh power be brought within 1 week, failure of which the matter shall be dismissed without reference to the bench. You see, in the event the power is regularized, the matter may be posted to 11th of May. We give you 9 days time.
Obliged.
Lord, for OP5 I am appearing.
Yes, we can.
Second copy. Lord, second copy is not filed. May I be permitted to just file?
The second copy of the counter.
Counter.
Substitution you are still having the power for the new company.
Pardon, my lord.
You are filing counter for the new company.
A counter already filed, my lords. Only noting shows that second copy is not filed.
No, you are no more.
No,
That has been taken
the
over.
affidavit may not survive
My lord, that
because somebody who was earlier of the erstwhile
No more
licensee because it is an official capacity. So you have to file an affidavit adopting that.
I will file affidavit.
One page
power also.
and also wakalatnama.
With
Also take
Regular-
wakalatnama.
with Vakalatnama, my lord.
We are posting it to 11.
11.
So file that after regularizing your power.
My lord.
না লিখিত হবো। However, appeals for the existing contesting opposite party. କରିବା କଥା। ନାଇଁ ଏଠି କଣ ହଉଛି ଶୁଣନ୍ତୁ, it's a request to the bar members, all counsels appearing in power matters. This is not a recent phenomenon. Tata has stepped into maybe 2 years back somewhere, 4 years back somewhere, 5 years back somewhere. So why are you not regularizing these aspects? केसटा कोन कोर्ट को आसिले ही आपण पाउचंती अपॉर्चुनिटी काई आपण को ऑफिस रे फाइल काढी करी रेगुलराइज काई करू नाहंती people will laugh at us 17 रो मैटर आसिला we go on adjourning then when we will complete this proceeding
My lord.
so आमे आम मर्जी ऊपर सब अदालत चलाउचे ई इंप्रेशन जीव सोसाइटी को so be careful here after जदी रेगुलराइज न होईची आमे डिसमिस कर दो
Well, they're
technical
taking steps
dismissal
now.
hava you will be put to some cost puni restore hava after taking steps technical dismiss kar do
Well,
it's not duty of court to remind you yes 5
Item 5,
5, I am for the petitioner. Here, the annexure 4 at page 40 challenged regarding claiming refund of area or energy bill.
no last time you were put
Your lordship has told that to remand the matter for fresh hearing by the GRF.
we have told
Yes, my lord.
No,
Because limitation point which has been raised by me before the learned forum below has not discussed anything in the impugned order. That is why your lordship has pointed out that
Okay.
to
where is your objection raising question of limitation
your lordship kindly have the
and
impugned order.
before that please take us to the demand in challenging the GRA
Demand, he has filed a petition before the GRF
against a demand
against the demand of rupees.
no where is that demand
Demand he has not filed before the
Yeah.
Lord.
You have come in a read petition. Why are you shifting the burden on him?
I have filed to challenge the order impugned order.
That's right. That doesn't mean the foundation demand will not be brought on record.
Well, your lordship can be, the complaint petition I have annexed, filed by the.
Complaint discloses what is the
Yes,
demand.
ma'am, yes, ma'am.
Okay, let us see.
Page 28.
But why are you shying away from filing the required documents? It's your read. माइजर काहेकि होउचंदी आपण माने आ दीटा डॉक्यूमेंट फाइल कर देले आपन को असुविधा हबो that rather supports your case that you don't file those documents page
Page 28.
yes 28
The petition therefore prays that honorable forum be graciously pleased to pass the order that respondents should follow para 190 so OERC tariff order for the year 13 and 14 strictly while levying reliability surcharge. Hence, the area and DPS amount of rupees 73,81,080 which has been paid along with the energy bills for the month of December 2014 and January 16 to be refunded to the railway immediately along with interest. Also, the respondent should refund the reliability charge surcharge amount of rupees 4,75,820 for the month of May 2019.
so you challenge that there was delay involved and
Yes,
there is no consideration on delay
Delay, your lordship.
delay then what is the provision when should one bring this litigation when should one bring this litigation that's right when this was filed
This was filed in the 2020.
2020
My lord.
yes registered in 20
Yes.
what is the law bringing in litigations in this regard
My lord.
is there any time framing
Yes, my lord. Lordship can give a glance to OERC distribution condition code 2019.
2019
My lord.
সিটি আপনার পারে ওটা কি বলতো এই প্রভিশনটা 19 কি পুরোনো প্রভিশনটা কাইন্ডলি শো দ্যাট
157.
a petition under
My lord.
no that ଆପଣ ଯଦି para 2 ଦେଖିବେ the petition
Okay.
the OERC has introduced reliability surcharge from the year 13-14
14, yes, my lord.
as per para 196 of OERC tariff order
My
for
lord.
the year 2013-14
14,
So tariff
but
order
you are
2013
showing a regulation of 2019
19, yes. This
How
is a
it-
so
tariff-
how 2019 regulation extinguishes all the earlier claims or proceedings
Yes, my your lordship kindly have.
so you straight away bring turn to that provision in 2019 which extinguishes all previous
Yes.
claims or proceedings
Yes, my
or
lord.
bars the previous claims.
Yes, your lordship kindly have a glance to regulation 157. Page 66.
Of 2019.
Yes, ma'am. One
No,
point.
you are then you have not followed the query. 157 deals with dispute after 2019 comes to force. The query is very specific.
Yes, ma'am.
For all pending query and grievances, everything is extinguished by 2019. Because your case is that this is barred by limitation,
and you are relying on a 2019.
19 notification.
Yes, ma'am, because.
So where 2019 notification provides for limitation, my lord asked you that you are yet to point out. Second aspect would be that pending disputes.
Because,
What would happen to them? They will be getting extinguished by after coming into force of 2019.
because he had, though
Listen,
the dispute.
It's not a question of
Please
because.
don't give a lecturer, come to provision.
Straight away come to the provision.
That this has been already, the issues already covered
So,
under the earlier.
If you say that 157 is the provision, then the contention has to be rejected. They are not relying on 157. The future after 2019 comes to force, future disputes will be governed by 157.
This is not a dispute covering that period.
But,
It's a dispute covering 13-14.
but your lordship kindly have.
You started with a point that there is dispute grossly barred by limitation. So take us to that provision. Why are you taking us here and there?
No,
sorry.
your lordship kindly have a glance. The provision says, if the.
What provision? Who is provision?
Your lordship
The
kindly.
only provision you have shown, it is not applicable.
No, your lordship kindly have a glance to the 2004 code even. Consumer has been.
So take us to that provision. 2004 code there. Mr. Rai, difficulty is you are not sure enough regarding the provision of law. Therefore, you are taking us here and there.
No, because it is a.
No,
dispute.
don't lecture. Straightway take us to the provision. Yes, this is the provision of limitation. One must bring the petition within this period. Don't take us here and there. You are sure 2004 helps you?
Yes, madam, your billing dispute. Regulation 91.
591. Yes, which provision you want to draw our
Regulation
attention?
91.
91.
Regulation 91.
Regulation 91.
My lord.
Upon OERC grievance redressal forum regulation 2004 ଦେଖଉଛନ୍ତି
Code, yes, ma'am, code.
grievance redressal forum ତ
No. OERC distribution condition supply code.
Okay, distribution କଣ ଅଛି ଆପଣଙ୍କର ଏଇ parallel ବହି ନାହିଁ no is somewhere else distribution of supply 2004
Code 2004.
ହଁ OERC distribution conditions of supply 2004
Code 2004.
हाँ
Yes, code 2004.
अरे बाबू सेटा पढ़िले आपण कोन से प्रोविजन टा पढ़िले
ORC distribution condition.
OERC distribution of condition of supply
Supply code.
code
2004.
2004-495. Yes, there 95.
91.
Oh, ये सब पुनी different मसिया ही जी तो हाँ ये वही रे 495. Then he says 95.
91.
91, sorry. 91 means आपण parallel वही सब धरना दिखाएंगे. Yes, dispute erroneous bills.
Yes, sir. In the event of any dispute, the bill amount, the consumer may lodge a complaint before the designated officer, public agency as returning the licensee and pay the average of last 6 months consumption or the bill amount whichever is less within the due date pending settlement of the dispute. The licensee shall resolve the dispute or communicate its decision with reasons. The consumer with a maximum period of 1 month as per the regulation 92.
ହେଲା 6 ମାସ ଭିତରେ ଆଣିବା ପାଇଁ
Madam.
6 ମାସ ଭିତରେ ଆଣିବା ପାଇଁ କୋଉଠି କହିଲା?
He has to pay the disputed amount.
Oh, Mr. Rai, you are only shifting. You are only shifting. We record had the submission of Sri Rai, learned counsel for the petitioner, appearing for the licensee. This writ petition involves the following prayer. Inter alia, in the challenge of the impugned order dated 24/7/2020, passed by the GRF Cutoff in case number 304 of 2020. Impugned order for the submission and the pleading herein. Also in reference to the objection raised by the petitioner, the licensee before the GRF appears to be the claim before the GRF authority, dispute before the GRF authority involved a barred by limitation claim. It is on the premises that in spite of raising the question of delay involved therein, the GRF has not taken into account the same and passed the order. The right for the above contentions praise this court for at least remanding the proceeding to the GRF for taking a decision first on the limitation aspect and then to proceed on merit if satisfies on the delay aspect. In the process of hearing, Sri Rai first attempted to drawing our attention to the provisions in the Odisha Electricity Regulatory Commission brought through, Odisha Electricity Regulatory Commission Distribution bracket conditions of supply code 2019 and taking this code to the provision at para 152 attempted to
66. Next page.
51 and 157 attempted to draw our attention that for the provisions herein applicable to the case at hand, the order must go, impugned order must go. Considering, okay, in his next attempt, Sri Roy taking us taking us to the provision at Code 91 of the OERC distribution bracket consumer of conditions of supply bracket with the Code 2004, particularly the provision at Code 91 therein, also attempted to satisfy his such conditions. Considering the above, getting into the Code 2019, this code find this code was brought by way of notification on 27th August 2019, whereas dispute involved before the GRF is a prior dispute. For there is no saving provision of the provisions of earlier code. Through the Code 2019, this code find Code 2019 has no application to the case at hand. Similarly, coming to the other ground of challenge through the Code 91 of OESC distribution bracket condition of supply Code 2004. This code find the Code 91 reads as follows. Okay, quote kariba, page 541 of this book. Yes, reading the aforesaid, it becomes clear there is no trace of fixing limitation on the part of the complainant in bringing disputes. In the circumstance, this court also find this provision has no support to the case of the licensee, the petitioner. On both counts, the petitioner fails in satisfying the court. And in the result, this court find there is no scope for interfering in the impugned order.
There is a repeal provision. There is a repeal of 206.
Yes, next case.
Urgent copy and my application.
Item 6,
You are appearing, Jateswara. All right.
For railway.
Railway pe hai na?
Well, the order of GRF Annexure 8 that is under challenge. I have challenged in twofold ground. First is the order passed is beyond the relief claim.
You challenge the GRF order.
Miller, Annexure 8,
Annexure
starting
8.
from page 27.
Let us see what is the direction of GRF.
But I am for the opposite part number 2. I am permitted to place 2 recent bills only because it was my original complaint was against.
Let him complete his case.
Okay, my lord.
We
Because there is
are
no-
yet to collect what is his case.
Yes, this shows there is no area. That is why
Mike agar ruantu.
the recent bill shows there is no area dues. So that is why you wanted to place.
No.
Okay. Let me.
Yes, since he opposes, you just wait.
Minus.
Okay, let him complete. Yes.
The opposite
What is
party,
the order? Page 34. Come to
Miller,
page 34.
the opposite party is directed to cancel the revision order number. That is a revision bill. Revision order number 522 dated 28/3/2019 of the SC Electrical BD3 South Co-Utility Barampur. That is Annexure 3 I have annexed. To revise the bill of the above complaint by this method, Your Worship, by replacing the new meter.
So which part of the order you are aggrieved?
But I have agreed that the direction that has been passed by the London GRF is the beyond the relief claim. Your Lordship, can look at
Whole
the,
direction.
yes, both
All the direction beyond
the
the claim.
beyond the relief claim.
Where? Let
Your
us see the
Lordship, can
claim.
look at their GRF petition. I have annexed.
Annexure
My lord, that is
6.
annexure Millard,
Six.
6, page 23,
Hmm.
the prayer. The Honorable Forum is requested to give direction to the opposite party number 1, accept rupees 1 lakh
No, come to his prayer.
Millard. Page 23. Their application before the GRF
Yeah.
and their prayer was to direction to the opposite party to accept 1 lakh 560 as down payment and reconnect the power supply immediately. And the order has been passed by setting aside our revision of bill. And my second argument is
In
that
the application, has he pleaded for setting aside that?
no, in their application they have not challenged it even after the revision of bill.
So this was simply an application for power connection.
Power reconnection of power supply and acceptance of their down payment.
Right. Why this acceptance of down payment? What is this?
Millard, there here is matter involves the fact remains that it is a Airtel tower. It has been installed in a water lodging area. It is not possible on everybody's part. They are also not remaining there because the water lodging, it is not possible to take meter reading. We are taking the meter reading on average basis. In November 2018, we took the meter reading and we found the unbilled unit that come forward. We raised the bill. 5 lakh some odd amount, we raised the bill. That I have annexed. That he raised a dispute, you revise the bill, reconciliation, revision the bill. We verified the meter. The meter is found okay.
So you say revision order was never challenged.
Never challenge your worship. And second argument is that the direct direction of the GRF in setting on the DOMP report 183 provides if any dispute on the meter.
Paragraph right. Paragraph reading of energy bill per month. But he is not giving a specific relief. That's right. In that even what will happen, the license is not. This disconnection is still continuing.
No. It has been reconnected.
Then how the power connection was given?
Because it is a telecom tower, they requested and deposit some amount. Therefore, we provided.
So therefore, you are succumb to his request.
Yes.
Then why are you partly settling? You can also settle the other aspects.
They are not coming forward. Problem is that.
No, Mr. Tripathi, he says very specifically,
Right.
showing your bills.
Right.
As on date, there is no indication of any area.
No,
And if you take
Yes.
their stand, page 22, just
Yeah.
kindly look at that.
Yes.
Just look at page 22.
In the
आपको brief नहीं
in their affidavit.
आपको brief ର page 22
Yes, yes.
ଆପଣ petitioner.
Yes, 20.
ତାଙ୍କର ଯୋଉ ପିଟିସନ ଟା ଫାଇଲ ହେଇଛି GRF ରେ
The location is at Sanapadara village.
Millard.
The power supply was affected during December 2010.
Millard.
From the day of charging, the Golonthara JE used to take joint meter reading.
Millard.
On the basis of reading, the energy bill per month were being served and the consumer regularly cleared the bill.
Millard.
The consumer never disputed the reading taken by the concerned JE, but suddenly when he received a bill during November 2018, basing on astronomical reading of 175941 taken on 1/11/2018,
Millard.
the consumer disputed.
Millard.
So you are saying that this was submerged in water, you could not take bill. So these 5 paragraphs is completely contrary to your stand taken in this court,
In their
where you have stated before the GRF
Millard.
that you never took the reading.
Millard, your lordship.
Because the JE would have signed that also. Golonthara JE in Sanapadara.
Millard. The joint meter, we have set it.
Sir, don't, I mean, indicate by gesture.
Will.
So always, I don't understand. Please show that where you have stated before the GRF that yes, there was no reading.
Page
It was submerged in water. Waterlogged area, you said. Koti deny kale se government.
Annexure
Paragraph,
7 Annexure 7 रे देखा तो
Annexure 7, paragraph 2 and 3, Your Lordship.
नहीं.
It is a fact that petitioner Bharati Infratel has installed a
No,
airtel
that
tower
is not there.
obtained such a.
Para 2 and 3 basically support the exactly matches the contention at paragraphs 1, 2, 3, 4, 5 in the petition.
Miller.
The bill, kindly read 3.
Miller. The bill for the month of November 18 is served basing on the reading taken by J. Golonthra, and as per meter reading, the billing was done, and the bill amount of 5,20,048
So on
was
the
served on
contrary,
the.
you say billings were metering was always
Miller.
done.
Because we could not take the metering reading because of water lodging,
Good.
therefore that was taken.
Where have you stated that? Where have you stated that? You don't read on your own.
Miller.
You can't put a word even.
Now that I asked them to why they have not
Sorry,
taken. And
this was
they
never
said,
your plea. This was never a plea. Therefore, once you have settled the reconnection issue, sit and settle with him. Otherwise, you are abided by the judgment of the DRF.
in my submission, the relief is, the order has been passed beyond the relief lordship claim. The relief claim.
So that impression you are gathering because you have a lawyer of acumen.
No.
So the petition may not be that well drafted, but you see your pleadings there.
No, that is.
So don't you have to stand on your own legs.
Miller.
Not because their prayer was something and the petition was something and it was not so well.
It is
But
not.
para 7, just read para 7 of your reply.
Mr. Tripathi, it is not always to be gone by prayer alone. Body has to be taken into account.
Your Lordship.
It is to be read together. A prayer is to be construed. Not that somebody failed in making a proper prayer, he will not be granted relief. Pleadings are there already.
But setting aside that revision order, that was not prayer, Your Lordship. That is not there. Their claim is not that to set aside their revision of bill.
So, you will be satisfied if it is that only 1 lakh will be deposited and the entire prayer is granted. Is it your submission that if the prayer is granted, you have no grievance? Then this court can suitably modify that.
That is your Lordship.
On your concession.
That I am not disputing.
But you have to record that concession.
My second ground
No,
of
please,
challenge.
Mr. Tripathi, don't evade that.
That is one ground of challenge.
No, not ground. Are you is it your submission that if the prayer as made before the GRF, if it is granted, you are happy with that?
No.
Then
That is even.
you are neither here nor there.
No, there is even no cause of action to that effect. You are already given power connection. You have
And
already given power connection.
I think since they are a large consumer, they have entered into a settlement. You have referred to that settlement also in your reply.
No, this short for settlement.
So
And we installed a new
so by revising, by setting aside the revision,
Miller.
you have accepted that 1,560.
No.
Then how can you either you say that you are happy with the prayer?
No, we are not happy with the prayer.
Then you have to challenge it.
Miller,
So you have challenged that it has to be decided on merits.
Miller, because my submission with Lordship is that on two-fold ground,
No, Mr. Tripathi, your submission is very clear that the GRF went beyond the prayer of the consumer.
Miller.
So definitely the necessary concomitant question would be that if the prayer is granted, because you are satisfied otherwise with the GRF order.
No, we are not satisfied with the GRF order because of we have challenged it.
You can't simultaneously blow hot and cold.
And that is without jurisdiction, Lordship. That is order is also without jurisdiction.
No, you say that the GRF cannot grant this order of acceptance of 1,560. Where is that stand?
Yes, the GRF, whatever my submission, Lordship, that GRF is created under the statute. The GRF cannot go, GRF cannot exercise the.
Sir, that point is well taken. You don't have to elaborate. It is not that the court has not got your point. But you are somehow avoiding to answer that if the prayer made in the GRF petition, the consumer complaint is granted, you will be satisfied. That you are saying you are not satisfied or you are avoiding to answer that.
No, we are not.
You make that concession, we will modify that order.
But we are not satisfied with the prayer, the order of the past. GRF.
Mr. Sahu,
And it is without jurisdiction.
Mr. Sahu, you are Mr. Mahanti, sorry, Mr. Mahanti. Was it operational all through?
Yes, my lords.
It was operational.
Yes, my lord.
Then why don't you go for a dump meter reading?
We have taken dump report. On the basis of dump, that revision was made. You know, with the dump
Okay,
report.
your present stand
Milord.
that it was submerged in water could not function, so or bill could not be
Served
taken
regularly.
for some time. That forget that.
Milord.
So you have taken the billing on the dump meter.
Yes, on the basis of dump report, that revision was effected. The GRF is disputing on the dump report, which is without jurisdiction.
So therefore there is no positional change. But what we find is he has exceeded in his jurisdiction when there is no specific prayer to this extent. ସେଇଟା କହିବା ସାଙ୍ଗେ ସାଙ୍ଗେ ଇ ଅର୍ଡର ଗୁଡା ଦେଇଦେଲା cancel the revision order କରିଦେଲା this may be subject to ଏମାନେ କହୁଛନ୍ତି କି para 7 ରେ they have already put up in no, but we can't step into the SOO thing here. To modify your prayer in the GRF.
My lords,
Because
in
your
fact,
prayer is confined only to take down payment of so and so and give us reconnection. Reconnection is already there in
Yes,
the
my lord.
meantime. So we'll protect the reconnection. You go on paying the current dues, and in the meantime you amend the prayer because your basic challenge in the GRF appears to be this revision order.
My lords, it was
Now
it was-
they in para 7 says, in the meantime as a reconciliation they have already put a new meter. And they found the meter reading almost equal to the previous
Yes,
readings.
so it was
Then what is the fun of again getting into another meter reading?
not required. In fact, there is a dump report, and my lords, in fact, in February there was an area of 15 lakhs, 88,000. In March they have cleared this clearly, so there is no area.
So you have accepted that.
So now it is reserved, my lords. As
No,
per
no.
their order, this is the bill. I can file.
New meter ରେ ଯାହା reading ଆସିଲା ତାକୁ
No,
reconcile କଲେନି
correct,
ଆପଣ?
I have taken.
ଆପଣ instruction କେବେ ନେଇଥିଲେ Mr.
କାଲି ରାତିରେ sir ନିଶ୍ଚୟ.
No, based on this,
On that.
you take instruction, let it come tomorrow.
Sure.
Don't guess it. You are taking too much of risk.
Reconcile ହେଇଛି କାହିଁ ଆମେ unnecessary waste
Necessary, ଆପଣ ବି କାହିଁକି because you are in a win-win situation.
Right.
Already you have got all the money.
Right.
So he's not willing to pursue with the opposite party.
ଆଉ GRF ର order ବି implementation ର necessity ରହିବନି.
My lord.
What 15 lakhs ଟା କୋଉଠି ଦେଖୁଛନ୍ତି Mr. Mahanti?
My lords, at page 3.
Page 3 of your affidavit.
My lords.
Which line?
It is in the
ହଁ
fourth,
ଏ 16,02,857.
yes, last bill,
Net
and area shows 15 lakhs 88,553.
Yes, net area 15.88. So there has been payment, clearing
Yes,
of payment, reconciliation probably.
And at page 8, it shows
Lordship, keep it to day after tomorrow.
Copy de diyantu.
In the course of hearing, it
Yes,
has
sir.
been brought to the notice of the court. Even in terms of response of the licensee at para 7 of their objection before the GRA, dependent on the fresh meter reading through annexure A, it has been established after rebate, net payable amount as on 8/2/23 appears to be 16,02,002,857. After deduction of net area, 15,88,553. Current bill was raised at rupees 14,304.46. Okay, this bill you have cleared? Yes, 14,125.
yes, ma'am.
ଦେଇଛନ୍ତି କି ଆପଣ ଦେଇ ଦେଇଛନ୍ତି?
Current bills we have paid.
Okay,
Area.
petitioner also claimed to have cleared the current bill. Not only for the month of bills raised, but not only for the month of January, page 3, but also March, page 4. February টা দিলেনি কাহিଁକି?
My lord?
My lord, they are saying that they have not paid that area.
No, no, no.
And submits that the matter has been reconciled in the meantime. Okay, CP Patil and counsel appearing for the petition. Copy is already served on the
Just sir.
I saw the
copy of
copy by
this
mail and
affidavit is
have supplied
already
a copy.
served on CP Patil. The Tripathi, however, wants taking update instruction. I'd like to respond the court further. Place the matter day after tomorrow. Yes, argument.
So Mahanti, you also take specific instruction, when did you pay that amount? If at all you have paid.
My lord, I'll take.
Because
Because it is not very clear.
payment receipts are not here. It's only bills are there.
I'll take it instruction by mail.
Public.
এটা সে মূলରୁ କହିବା ପାଇଁ ଚେଷ୍ଟା କରୁଥିଲା। Right.
Item 7.
Your Lordship, I'm for Senior Counsel Soumya Mishra. He's suffering from food poisoning, so I request.
Pardon?
He's suffering from food poisoning, so I request to adjourn the matter to next week.
Food poisoning. सोमवार दिन कौन एमती खाइदेले कि सोमवार टा परा शिवबारी यंग लोक सब डाइजेस्ट कर दवा कथा this has been admitted. Yes, interim order is continuing. All right, day after tomorrow.
Yes, Your Lordship.
Only on the ground of illness of the learned counsel for okay, Sri Durga Prasad Nanda, Senior Counsel appearing for OP3 present. Here अछंती बबीता साहू केंद्र सरकार के नांति लिखि दियो नॉन appearing for the central government. केंद्र सरकार 2000 टका बंचै दिन day after tomorrow.
Your pleasure.
ए बबीता साहू पछरे आसिले आपण पाइबेनी प्लीज आमे रेकॉर्ड कर चलुनु आमे रेकॉर्ड कर चलुनु नोबडी देयर ओ बबीता साहू ना ठीक है सर.
Item 8.
Miller, item 8, Miller, I pray for an adjournment of this case.
ठीक है. All right. Please.
My lord, it has been it has been
I pray
adjourned
for an
several
adjournment.
several
I
times.
pray-
It has been adjourned.
कौन करिया
Let it be hard today.
Miller, it is regarding shifting of that pole, Miller.
LC
Pole
line.
cannot
बोल
be-
पे आपण कर दो ना कहीं कौन पे आपण टाइम नउचंती
No, but
are you in
time
a
of-
process are you in a process of settling
There is some personal problem. I pray for time, Miller.
ଆପଣଙ୍କ ନିଜର personal problem,
Milord,
ଆପଣ ନିଜର personal problem.
sir, something changed in the meantime. And Milord, regarding my
In the
regarding my
improvement or in the
engagement, regarding
deterioration?
my engagement, something changed.
In the improvement or in the deterioration?
Milord, your lordship, voice is not audible to me, Milord.
Best ground for adjournment. He is taking best ground. I am not able to hear you. All right, day after tomorrow. As a matter of fact, day after tomorrow.
Milord, next week, Milord,
Come.
next week.
Come
Sorry,
after
sorry.
vacation, otherwise
Sorry,
let it come after vacation.
After
there is
vacation.
stiff resistance because this matter has already been adjourned for so many.
Milord, let it come after vacation.
And the matter has come to 13 dates. Hello. There is stiff objection in the adjournment of the matter today, considering difficulty, personal difficulty with Sri Das. This matter is adjourned to day after tomorrow.
Milord, let it come after vacation.
Day after tomorrow, Sariva case.
ଆଜ୍ଞା ନହେଲେ ଆର ସପ୍ତାହ
Haba no haba.
next week.
Aro saptah.
Aye.
Or next Tuesday. Next Tuesday, it is made clear there shall be no further adjournment of this matter. Yes.
Item 9,
On being requested by Sri Das করছো তো? Yes, item 9.
Yes, I am for the petitioner. My lawyer friend Mr. Amya Kumar Mohanty.
Please be on mic.
Yes.
ବୁକ ଗତିର ଚଳଚିତ୍ର କେବେଠୁ ଆବୁଲିସ କରିଗଲାଣି? ମାଇକ ଆଗରେ ରହନ୍ତୁ।
ଆଜ୍ଞା ଏବେ ଶୁଭିବ।
ଆଉ ଟିକେ ଘୁଞ୍ଚି ଯାଆନ୍ତୁ ଆପଣ।
ନାଇଁ ଶୁଭିବ।
ନାଇଁ ପଢିଲା ବେଳେ ଆପଣ ପୁଣି ତଳକୁ ହେଇଯାଉଛନ୍ତି।
ନାଇଁ।
ହଁ। Yes.
Here the management
same problem.
Just bend the stem toward
you please
still further below.
You please shift to 1 feet to your left.
ଆଜ୍ଞା।
ଆଉ ଫୁଟେ ଘୁଞ୍ଚି ଯାଆନ୍ତୁ ଆପଣ।
ହଁ।
ଫାଇଲ ପତ୍ର ଧରି ଘୁଞ୍ଚି ଯାଆନ୍ତୁ। ନାଇଁ ଆପଣ ସେମିତି ଘୁଞ୍ଚୁ ନାହାନ୍ତି। ଫାଇଲ ନଉନାହାନ୍ତି ଆପଣ ପୁଣି ପଳେଇ ଆସୁଛନ୍ତି ଫାଇଲ ପତ୍ର। ହଁ ଆଗକୁ କଣ?
Now here I am for the management. My lawyer friend Mr. Amya Kumar Mohanty is for the workman.
Right, କଣ ଆଗକୁ କରନ୍ତୁ କଣ
Now
matter?
here the question is CGIT Bhubaneswar did not have the jurisdiction. If your lordship will kindly look to the reference.
No, what is your challenge first? Make it clear.
Challenge is the award.
You challenge the award
Yes.
of an industrial tribunal.
Yes, CGIT.
CGIT, Central
Yes.
Government
The
Industrial.
point of reference is at page 44.
Okay, on the ground.
On the ground, no, first objection is that CGIT Bhubaneswar doesn't possess the jurisdiction because it involves the entire Hindustan Aeronautics, which has 8 branches, 8 divisions throughout the country. And the reference itself should have been to
there is part of cause of action in the state.
In the
One of the unit is in the state.
Yes, in this.
So therefore, if your contention, Mr. Das, if your contentions will be accepted,
yes,
then no state wherever this institution is operating
my
can hold.
My responsible submission would be looking to the point of reference. 2 references were made.
Okay, what is the reference? Let us see.
At page 44. Whether the action of the management of Hindustan Aeronautics.
You have not filed the referral notice. You have not filed the reference notice.
The award I have annexed.
Where is the referral notice? There must be a notification. No, that is quoted, no doubt. Page 53.
No, that I have not annexed.
Page 53 probably there. Then just see. Yes, it is there. It is there. Annexure 2.
Yes.
Besides that, the award contains first.
No, तो आगे पढ़ो देखिए reference टा कौन ହେଇଛି से कौन take up कले. So you have multifarious grounds. One being question of jurisdiction.
Yes.
Okay. Now come to the reference. Read the schedule.
Reference is at page 44, quoted.
Yes.
Whether the action of the management of
It is
Hindustan
page 53.
53 is that whereas the central government is of the opinion that the industrial dispute exists between the
Yes,
employee,
please, author padantu. Whether the
whereas the central government is of the opinion.
whether
Yes,
ସେଗୁଡା
the
ପଢିବା
schedule-
ଦରକାର ନାହିଁ.
ଆଜ୍ଞା,
Schedule ଟାକୁ ପଢନ୍ତୁ. Reference ଟା
whether the
50-14.
action of the management of Hindustan Aeronautics Limited in treating the recruited watch and ward guard in the year 2004 are treated junior to the watch and guard recruited in the year 2006 and 2008. Second, whether the circular of Hall Corporate Office, that is at Bangalore, number such and such, dated,
Circular Bangalore, don't read, say that.
dated,
Bangalore is the head office, therefore
Yes.
it's natural.
Yes.
All circulars will come from Bangalore.
corporate office.
But it
yes.
must be
Ten-
governing all
Yes,
this
yes, it
establishment.
is of such type. 10th,
Therefore, it has an application in Orissa.
dated 10th November 2008, in considering the past service of watch and ward guard in conformity with the directives of the government is legal and justified. If so, what benefit the 35 watch and ward guards?
Where these watch and ward guards were working?
They were working at Sunaveda.
Sunaveda, so
Yes.
therefore there is a cause of action.
But the reference
So
itself,
therefore there is a cause of action in Odisha. Don't argue that.
no, that was the objection raised in the sense,
You might be raising objection to take out the jurisdiction, but it's not sustainable.
in the sense,
Workers were there working undisputedly in Sunaveda factory.
Sunaveda factory and
The industrial unit, the unit involved here is a central government unit.
yes,
Having located head office, having located in Bangalore,
yes.
having branches in several parts of the country.
Eight places.
So cause of action relates to one of its unit in the state.
Sunaveda.
Workers are working here.
Yes.
There is straightway cause of action. Please don't waste our time in that way.
But the
So now come to other part, other aspect you have challenged.
but the circular,
Yes, you argued circular is issued in head office in Bangalore.
yes,
That cannot take away the jurisdiction.
my this first contention is that it affects the entire watch and ward guard throughout the.
No, why? This is the answer must be for 35.
No, their policy is the number of years one has worked in the defense. Once he is recruited into HAL, any of the.
So come to
division.
merit. You
Yes.
can argue on merit that there is a wrong award. That you can argue, but don't go to the jurisdictional aspect.
I had thought of the jurisdictional aspect to be considered first.
No,
by
you
your
can't argue. At least I am doubly satisfied. I am doubly satisfied.
The argument note that I had.
Yeah,
submitted-
Aguru industrial tribunal nothila. I talk of my father's age. He used to go to Ranchi and all through India they were holding camp courts. That was only the central government tribunal. Then the prospect came to each state to have industrial tribunal.
Yes.
Then prospect came, there are central bodies. So industry is governed under the state. State is the competent authority, will come under the state industrial tribunal.
Looking to.
Also posted at Bhubaneswar. Then question comes, there are central government organizations, like hela, SAIL hela, NALCO hela. They are having multifarious establishment like this
HAL.
HAL also.
Looking to section 7 capital B.
So there was introduction of the CGIT.
Yes.
Nowadays CGIT has started sitting in all states.
Besides the national.
It's a national, it is taking up the central government agencies.
Yes.
Issues in Jodi, central government is the appropriate government. Jodi
But-
state government, appropriate government, state with the rest. So therefore forget about jurisdictional.
No,
Come on arguing on.
May I seek your lordship's attendance to section 7 capital B and the reference. looking to the reference made and section 7 capital B
Diyantu, idea,
IDEA Act, my submission first of all will be that the jurisdiction of the CGIT Bhubaneswar is not there. It has to go before the National Tribunal.
So that's also please take note of that reference. The mechanism of reference has to be also taken note of. Whether that has any impact on the adjudication or not. Because that subsection 1, subsection 2 of section 10,
Again.
please mark that also.
Section 7 को कहीं अपन refer
No,
करते हैं?
section 7B, in view of the nature of the reference, section 7 capital B, the central government may, by notification in the official gazette, constitute one or more national.
No, this national tribunal is CGIT.
Again.
This national tribunal is CGIT.
No, national tribunal had been constituted at 4 metropolis. Delhi, Bombay, Calcutta.
So that you have to read along with 10. Because this is a challenge post reference.
Will also be referring to section 10.
Yes.
Whether the appropriate government is, where the appropriate government is of opinion that any industrial dispute exists or is apprehended, it may at any time, by order in writing, refer the dispute to a board for promoting a settlement thereof, or refer the matter appearing to be connected with or relevant to the dispute to a court of inquiry for inquiry, whether the dispute or any matter appearing to be connected with or relevant to the dispute, if it relates to any matter specified in the second schedule, to a lower court for adjudication.
So A, B, C, D per se doesn't impose any restriction as far as the jurisdiction is concerned. Then kindly take one capital A. Whether that also imposes any restriction. Next
Yes,
page.
yes.
One
Whether the central government, where the central government is of opinion that any industrial dispute exists or is apprehended, and the dispute involves any question of national importance, or is of such a nature that the industrial establishments situated in more than one state are likely to be interested in or affected by such dispute, and that the dispute should be adjudicated by a national tribunal, then the central government may, whether or not it is the appropriate government in relation to that dispute, at any time by order in writing, refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it relates to any matter specified.
Is there gazette notification of this award?
Pardon, my lord?
Is there gazette notification of this award?
So only in case of one capital A can be national tribunal comes into picture.
Yes.
Otherwise,
This is the direction also by the award for implementation of, in the state unit. It has no far-reaching consequence.
And the industrial dispute is raised by the kindly mark this itself, that notification, page 53.
Industrial adjudication that is unless notified, it can't be implemented. Notification helani ki award ta.
Said, sir, I have no instruction if it has been notified.
Notified?
No, I have no
No,
information
you
about
should have
it.
taken instruction on that. Unless a award is notified, it has no force.
It was
And the disputant is General Secretary, Hindustan Aeronautic Mazdoor Sangh, represented through General Secretary. That is another aspect. Because one capital A power, your contest is that one capital A is to be exercised, but the central government is to be satisfied with that. It is too late on the day that you say that it is national.
You should have challenged that at
that
that point of time.
was
if you are
raised before the
dissatisfied.
CGIT bonus.
So once a reference is made and you have surrendered unchallenged.
No, that was challenged.
That was challenged, then what happened?
it was said that it was not very much emphasized by the.
So therefore that issue has gone.
In that I may be permitted.
That
to
issue has
submit.
gone then.
But I may be permitted to submit, but can the consent of parties give jurisdiction or take away
No,
jurisdiction?
here it is not consent, it is statutory.
Statutory.
10,
for
10,
this
10,
statutory-
10 1A or 10 1 small a.
Yes.
Both are statutory. It's not a consent. I mean, expecting this argument. So that is how I am able to answer you.
No, the
Here the statute provides a mechanism for reference.
Yes,
10 1 small a,
yes.
10 1 dash capital A.
And subject to satisfaction.
So this 1 dash capital A is the power to be exercised by the central government, not by the tribunal to decide whether this power is exercised or not.
In case a reference has been wrongly made to a particular tribunal,
Absolutely. So either it has to be no reference wrongly made under 10 small a or 10 1 capital A.
then capital
So
A.
your point is that only way it can be exercised is 10 1 capital A. Perhaps that is to be considered.
10 1 and 10 1A, both.
Both. One capital A is for national issue,
National.
and here there is no national issue as such. The litigation is by the Sunabeda Mazdoor Sangha.
Maybe.
The
but
members are of Sunabeda.
it has originated from there, but the question involves the total length of service as watch and ward in the defense, either Navy, Air Force
No,
or Army.
but you did not answer my lord's query. Then where it should have been filed? Your answer is that it is national. So national, the reference is different. National for a national tribunal to be taking up the matter, the reference is not 10 1 small a.
by the
Here
central
the
government.
Here the reference is 10 1 small a.
No. Here the reference is section 10, subsection 2A.
Yes, 10. I mean the first part.
2A.
I stand corrected. The reference is first part, not 10 1 dash capital A.
Yes.
The
You
award
come to
speaks
page
of-
44, the reference, even reference notification also.
53.
Award refers to the reference at the first
Yes,
part.
it is
At page
subsection
44.
1 and subsection 2A of the section 10.
Yes.
Therefore, it is only to be made by the central government. And that too, you say you have already challenged that. Where have you challenged?
Before the tribunal.
You challenge the, no. That you may challenge, there is no issue. Reference itself should have been challenged.
At the inception.
Yes,
But that having.
yes,
not
you
been
should
done-
not have allowed the industrial adjudication to proceed.
But that having not been done, the question was raised before the tribunal
No,
itself.
then tribunal loses its jurisdiction.
No,
Problem is that it is a reference. Kindly take page 53.
Issue was also framed. First issue.
And it is answered rightly, Mr. Das. There is no point in arguing on that. If you have an argument on merit, argue. If you have an argument on merit, argue.
I have.
What we find here is
Oh, yeah.
to what extent tribunal can go in these matters. Here he has asked the establishment to take these people in regular cadre.
No, the dispute involves such an aspect that it will be touching all the divisions throughout the country.
Eta watch and word to?
Oh, yeah. Their principle, their the policy is depending upon the duration in the defense, their recruitment is made to the categories throughout the country. So in case of Sunabeda, such policy was adopted. So my contents.
ଆପଣ ଏବେ recent decision Supreme Court ର ଦେଖିଛନ୍ତି? Maybe 2 days back, Supreme Court has come on a decision holding the entire period of work charge employee. This is watch and word.
Watch and-
That is work charge. Employees cannot be taken up for pension. It will be only for a limited purpose for counting to make deficit of minimum pension.
Same as Odisha, Bihar rules.
That Bihar.
Minimum pension 10
Same
years
as Odisha rules.
So therefore, you can draw an analogy through that decision even.
Well, let
They
me-
can't be treated as regular employees.
let
Will you
me-
please take page 53? It is a reference under clause D subsection 1, subsection 2A. It is not. So if you wanted a reference to national tribunal, it has to be different altogether. And whether this state government, the central government, the appropriate government can exercise that power, that he
ଆଉ
should have
ଟିକେ
challenged.
ପଢିବାକୁ ହବ ଆଉ ଟିକେ ପଢିବାକୁ ହବ
No,
ଶୁଣନ୍ତୁ ଆଉ
that
ଟିକେ
I admit.
ପଢନ୍ତୁ ଆପଣ.
That I
Yes.
admit.
There is
But
a
since the-
concept of a labor code.
Again,
There is a concept of a
Tribunal.
industrial tribunal. There is also a concept appearing to be national tribunal. Okay, there are 4 national tribunals. But what are the subject to go to national tribunal? Possibly,
again.
which awards have a bigger ramification or application to the whole
Yes.
nation, having application to all establishment of such establishment,
Sure.
repercussion ଆସିବ ତାହେଲେ ହୁଏତ national level ରେ decide ହବ. They may be engaging all trade unions in such organization and they may give a award. But here it is the issue appears to be, or the reference appears to be confining to this establishment alone.
But this establishment, the same policy is being followed. The duration of service as watch and guard or guard in the
Then you
defense.
should have blocked at the threshold itself.
That having not been done since the entire matter is now, if your lordship.
So a decision.
That it can also be
No,
gone
it is
into
very
at this
specific,
stage.
Mr. Das.
It is specific.
It's very specific. Kindly take the schedule at page 53.
Sir,
33.
If so, what benefit the 35 watch and ward guards recruited in 2004 at Hindustan Aeronautics Limited, Sunabeda, is entitled to?
sir.
So therefore, why do
So the reference itself appears to be not to be in 10,
Because that
can be expanded to 10(1)(a).
No, that having arisen from Sunabeda, but the policy is a policy of the Hindustan Aeronautics applicable throughout the
It
country.
doesn't refer to that. It's very specific, recruited in 2004 in Sunabeda and what they're entitled to. And it is 10(1) small, 10D small 1, 2A, 2 capital A.
Not concerning national.
Where is your written statement?
Written statement starts from.
I have annexed that. Yes, starting from page 62.
Huh?
Starting from page 62.
5-2.
62.
6-2.
Sir.
Where have you taken that stand?
Point number 218, 63 and 64.
Where have
Your
you
Lordship,
taken
may
that
kindly-
stand? They are all recruited by such policy.
Sir, page 63, your lordship may kindly turn towards the middle.
Page 63.
Sir, 2.1.
2.1, yes.
As may be seen from the provisions under section 10(1)(a).
No. We mean to say, where have you referred to your circular being the route of appointment? It is on the appropriate government. We are not there. Now you are raising a question that it has a far-reaching consequence because of
Yes.
the all India circular operating.
Sir,
Or the company policy. Come to page 66, there is some trace there. Once this award is given effect to.
circular start
area,
from page
people will come forward in
90.
raising disputes and they are to be bound by. So if it has a far-reaching consequence, maybe he has a point that this should have been taken up in central level, involving all units. See, he has guideline circular ଟା ତାଙ୍କ policy ବିଷୟ ସେ refer କରୁଛନ୍ତି. These are contractual employees.
initially they were recruited as contractual, but subsequently
সেটা হচ্ছে,
since 2006 they have been
existing, right?
regularized.
Point of jurisdiction also. Take up করছেন. 2.5. 2.4, 2.5. 2.3,
Sorry.
you have referred to the policy. So therefore, please have further research to find if it has a far ramification or repercussion,
Sir,
then it should not have been taken up by this and there is no proper consideration, you may allege. Out of Padontu,
sir,
it's a serious issue. Workmen ପାଇଁ କିଏ appear କରୁଛନ୍ତି?
my right friend Mr. Mohanty, Omniya Mohanty.
ଆମ ପଛ ସିଟରେ କାହିଁ ବସୁଛନ୍ତି? ଏପଟେ ରହୁନାହାନ୍ତି। Yes, are you prepared? ନା ଆପଣ prepared for adjournment?
I am prepared for hardship. We will not hear Mr. Mohanty, so that
Mr. Mahanti ko ପାଇଁ?
yes,
Mr. Mahanti doesn't want I should hear this matter.
that your lordship denies for
No,
that.
no, that is that
No,
you
see-
say, I don't say.
No, he is interested to
He is interested. Then why are you bringing that?
today is absent.
Oh, no, if you say I will not hear, I will send this matter
No,
to
no, he's
someone.
not. He's interested to hear. Let's say your
Then
lordship.
why do they do? Yes,
Any other day, let's say.
yes, Mr. Mahanti ଆସନ୍ତୁ ଆର୍ଗୁ କରିବେ। ଏବେ ବର୍ତ୍ତମାନ ସବୁ ଏଥିରେ ଆସିଗଲା। ଲୋକ ଦେଖୁଛନ୍ତି। ତେଣୁ ସଂଶୋଧିତ ହେଇକିରି ଆର୍ଗୁ କରିବା ଦରକାର ଆଉ କୋର୍ଟ ଉପରେ ଚଢିଯିବା ଏସବୁ ଯୋଉ ଅଭ୍ୟାସ ଗୁଡା ଛାଡିବା ଦରକାର। Yes, case.
ମୁଁ ସେଟା କହିବି ଆଜି ଥାଉ ଆଉ କାଲିକି ପଢ।
So prepare accordingly. Hard in part କରି ରଖୁଛୁ। ହେଲା hard in part କରି ରଖୁଛୁ। Hard in part. ଆଣନ୍ତୁ ସବୁଗୁଡାକ ଉପରେ Mr. Das.
ଆଜ୍ଞା।
It's a serious issue. ହେଲା। So we consider accordingly. You bring all this. You have a specific allegation in the or averments in the written statement we find. So then you find out a decision. ଆଗରୁ ସବୁ ଥିଲା ଶୁଣନ୍ତୁ ସେ ଯୋଉ CGIT ଟା ରାଞ୍ଚିରେ ଯେତେବେଳେ ବସୁଥିଲା ସେତେବେଳେ some issues were taken up by Ranchi Industrial Tribunal. That was National Industrial Tribunal. And CCL, MCL cases were being taken up there. SAIL cases were being taken up there. For the reason, SAIL was having the establishment over the country.
As in this case also.
MCL is also having.
Yeah.
Now HAL is also having. Therefore, you will find definitely. କିଛି ନହେଲେ 61, 62, 65 ଭିତରେ definitely decision ଥିବ.
Obliged, I will find out.
And you also bring a decision that once you have forgone these issues,
At the time of reference.
that cannot preclude you from agitating
it
such
during
issue
the
because
course
this may be a question of law.
Yes.
So there is no question of abandonment. That also decision ଆଣନ୍ତୁ।
That's all.
ଆଉ ଆପଣ decision କିଛି ନାହିଁ କଣ examine କଣ କରୁଛ case? ସିଏ ତ ସରକାରୀ ଓକିଲ ଏ କୋର୍ଟ ସେ କୋର୍ଟ ଦୌଡୁଥିବେ।
Yeah, temporary.
I didn't try. Place the matter next Tuesday ଆସିବ।
How to get long?
ହେଲା you also ଆପଣ sufficient indication ପାଇଗଲେ ଧରିକିରି ଆସନ୍ତୁ।
Yeah, how to get long? ଛୁଟି ପରକୁ ଦେଇଛି। ଛୁଟି summer vacation ପରକୁ
Oh,
ଦେଇଛି।
you also want to take it away from us?
No, question doesn't
We
arise.
find we got a scope to deliver a judgment on a very big issue. ଆଉ ଡେରି କରନ୍ତୁନି ସେଇତିକି ବେଳେ କରିଲେ ଆମେ ଦେଖିବା ଯଦି ହେଲା next week ପର୍ଯ୍ୟନ୍ତ ଚାଲିବ ତାହେଲେ ଆମେ vacation ରେ ଆମେ ଗୋଟେ ଗଢିବା ପାଇଁ ଚେଷ୍ଟା କରିବୁ।
16 ତାରିଖକୁ ଥାଉ। 16th
ରେ ଆଉ ସେତେବେଳକୁ ପୁରା vacation mood ହେଇଯିବ। 11th କରିଦିଅ ଆଉ 2 ଦିନ ଦେଲି ଅଧିକା।
ଆଜ୍ଞା।
11th। ଆଉ 2 ଜଣ ଯାହା written note ପୁରା ଧରିକିରି ଆସିଥିବେ। written note with citations. ହଁ। Yes, 10 number ଟା କଣ?
Item 10.
May please, my lord. My lord, item 10, my lord, the petitioner is challenging the award under Annexure 5. Here, my lord, the petitioner's prayer has been rejected on the ground that he has voluntarily abandoned his service. Here, my lord, the fact is that in the year 2016, the petitioner was appointed as executive logistic. After working till 9/1/2019, he has worked under Aditya Care Hospital. In the meantime, my lord, in the month of November 2018, some of the workers got transferred to the quality care hospital. But since the petitioner has not received the order of transfer, he continued in the Aditya Care Hospital. And on 10/1/2019,
What is the link between quality care and Aditya care?
pardon, my lord.
What is the link between quality care hospital and Aditya care hospital?
Both hospitals were working together. Then the quality care hospital
one
got shifted
management.
to its new place.
Under one management.
At that point of time, it was under one management.
Now, when you lose job, what was the status?
That was shifted to quality care. Management was quality care.
How do you succeed once there is a finding on abandonment of job?
My lord,
It's a factual finding.
my lord, for abandonment, to constitute abandonment, there must be complete or giving up the duties. Whereas, my lord, the petitioner, only because he has not received the order of transfer, he was unable to join in the new place of posting in quality care. And to terminate one employee, there
When the order of transfer was passed,
the order of transfer was passed in the month of November 2018, but the petitioner has not received the same in the
November
2018.
So you say because I did not receive, I could not be able to join.
I was unable to join in my new place of posting.
So this is abandonment of service on account of transfer order.
Yes,
not
ma'am.
joining even after transfer order.
Yes, my lord. And my lord, for terminating an employee, the procedure has to be followed. They should have instituted a proceeding against me.
What was the condition of service?
I was working as executive logistic, my lord.
Executive?
Logistic.
Logistic.
The post name is executive.
So that must be a term condition for appointment?
My lord, the terms and I have enclosed the appointment letter.
Executive logistic hele, apan workman kemti hele?
My lord, that finding is in my favor. That is at
your favor.
Yes, my lord. That is at page number.
Okay, all right. So therefore, with that finding even, where is your statement of claim?
My lord, the statement of claim is available in your lordship LCR, my lord. LCR has been called for.
You don't file.
My lord, I have filed the written note under Annexure 3
No,
and the
there is no
dispute to the
question of
TLO
filing.
under Annexure 2.
Filing note will not subside.
Annexure 2 have filed the letter to the DLO, and Annexure 3 is the written note.
Come to your service condition Annexure 1.
My lord.
What are you doing now?
My lord, I am out of job since 2019, my lord.
Now there is nothing. You are not doing anything.
No, my lord.
କାହିଁକି ଆପଣ ତ ଏଠି ଏକ୍ଜିକ୍ୟୁଟିଭ ଥିଲେ ଆଉ ଗୋଟେ କୋଉଠି ଯାଇ ଚାକିରି କରିପାରିଥାନ୍ତେ କଣ ଏଇସବୁ ଚାକିରି ତ ବର୍ଷିକିଆ ଏକ୍ସଟେନସନ ତାର କଣ ପରମାନେନ୍ସି ଜବ କିଛି ଅଛି ପ୍ରାଇଭେଟ ହସ୍ପିଟାଲ?
My lord, he was at the time before he was retrenched, my lord.
Come to page 14, the termination of service condition there.
It is to be clearly understood that during period of probation referred to under clause 4 above, your employment may be terminated by the organization at any time by giving a week's notice or payment in lieu of notice. An employee shall be required to give a prior notice of 1 month in case of resignation during probation period.
So that is all probation. Then
on satisfactory completion of probation, either party may terminate.
You are not in probation.
No, my lord, I was not in.
Then notwithstanding above,
either party may terminate the employment at any time by giving to the other party written notice of 1 month or payment in lieu.
No, that is in case of probation.
Yes, ma'am.
Next, pardon,
notwithstanding the above, the organization reserves the right at all time to terminate your employment forthwith without notice or payment in lieu thereof. If in the opinion of your head of the department or head of the unit, you are involved in persistent misconduct and irregularity or any indictable offense or inefficiency. In such an event, without prejudice to the organization's rights at law and or under the other.
So therefore, in the given circumstance, they have a right to take your service.
my lord.
So what, you may argue that the conduct here is not inviting such irregularities.
My lord, there is a
So therefore the statement of claim remains vital.
My lord, the statement of claim is also available in the LCR, my lord.
Oh,
Oh, the annexure 2
why have you not filed it?
my lord,
Your party must have contested in industrial adjudication.
yes,
So why he has not got with the
but he
copy
has
of the-
provided the written note under annexure 3.
Why written note?
Annexure 2 and
Written
2
note cannot convert to be a statement of claim.
of claim, my lord. And under annexure
ଆପଣ file ରେ ଅଛି ନା ନାହିଁ ଦେଖନ୍ତୁ। Arguing there in LCR. ଆମେ କାହିଁ LCR ମଗେଇବୁ ଆପଣଙ୍କ ପାଇଁ?
my lord, LCR in record noting.
Find out ଅଛି କି ନାହିଁ ଦେଖନ୍ତୁ। କାହିଁ ଆମେ ମଗେଇବୁ? ଆମେ କାହିଁ LCR କୁ ଯିବୁ? ତାଙ୍କ case he is to make out. First learn how there should be a pleading in industrial adjudication. First part in the pleading in a writ application is
Statement.
involving industrial adjudication is your statement of claim if you are a workman.
My lord.
Even if management comes, that is the foundation of the case. Like plaint in the first appeal or second appeal. Why should we rest on LCR?
My lord, I will
Your
file.
brief must be complete.
My lord, I will file and file the statement of
Then
claim by way
number
of-
2 is written statement.
My lord.
Then number 3 is evidence copies.
Well.
These are all. And number 4, if you so like, you may put the documents you have relied.
My lord.
ଆପଣଙ୍କ ରେସ୍ପନ୍ସିବିଲିଟି କରିବେନି କହି
My lord, I will file an additional, I will file the statement
ଆପଣ
of
ଫାଇଲରେ ଅଛି କି ଆଗ ଦେଖିଲେ? Let me check whether you have filed the writ without a copy or with a copy. Written note is the last resort. ସବୁ ସରିଲା ପରେ written note ଟା ଫାଇଲ ହୁଏ। ଅଛି ଆପଣଙ୍କ ଫାଇଲରେ ସେ କପି ଅଛି? ନା ଆପଣ ବି LCR ଉପରେ ବ୍ୟାଙ୍କ କରିବେ? କୋର୍ଟକୁ ଆସୁଛନ୍ତି ଆର୍ଗୁ କରୁଛନ୍ତି even you are not remaining careful to find the copy with you.
The statement of claim was available in this file.
Huh?
Now it is not available, my lord. I will file by way of.
ଆଚ୍ଛା ଦେଇଦେଲେ ସେ ରିଟ୍ ଫାଇଲ ହେଇଗଲା ପରେ ତାକୁ ତା କାଗଜ ଗୁଡା ଫେରେଇ ଦେଲେ।
Stapler ଗୁଡା ସବୁ ଖୋଲି ଯାଇଛି ତ ସେଟା କୋଉଠି misplace ହେଇଯାଇଛି।
Place this matter after vacation. In the meantime, petitioner, counsel for petitioner is directed to bring in copy of ପାଇଁ କିଏ appeal କରୁଛି?
My lords, I may be permitted to make my submissions to virtual board. I am appealing for the management.
Where is your gown? Oh, it's not necessary.
Lordship, I am sorry.
It's all right. In the course of hearing, this court observe, VC hearing, this court observe the counsel, learned counsel. Your name, please?
My lords, Sushant Das.
You are also
Sushant Das, my lords.
Sushant
I am
Das.
sorry, my lords.
Appearing on VC is not in proper attire. Even though this case is adjourned to next day, participation of Sri Sushant Das will be allowed subject to is depositing a sum of ₹3,000 in the Advocate Welfare Fund, High Court of Orissa. The Bar Association, High Court Bar Association, Qatar. In the meantime, the petitioner is directed to bring on record a copy of the written statement, a statement of claim, as well as the written statement of respective parties. Yes. You take instruction, say back wages nebeni reinstate kariparibe ki?
Your Lordship, yes, Lord.
Because it may not be a clear case of abandonment of service. Yes, if even suppose there is a stray of material that he has refused to receive the order of transfer, then the procedure for
Lordship,
termination should have been adopted.
Yes, Lordship, I will satisfy, I will take instructions and I will
Take
also.
instruction, take instruction, he may abandon the back wages. You also convince your party.
Yes, ma'am.
You may abandon back wages and you will be reinstated.
Maybe reinstated. Obliged.
Obliged, Lordship.
Record for this court, direct.
Mr. Jena, he should not be stubborn. I think what fell from my lord, you must understand.
Only, my lord, I will confine it to
You
reinstatement without.
check the evidence, Exhibit 9. There something which the court has taken note of.
Persuade your record.
Persuade him. He should lose some to win some.
My lord.
कम दरमारे जब 19,000 टंका चाकरी करथिले, so that
Counsel
should
for
be considered.
workmen when directed, counsel for workmen when directed to take instruction as to if his client is ready for foregoing the back wages and will be satisfied only with the reinstatement order. At the same time, the counsel for management, see, the counsel for management is also directed to obtain instruction if they are ready to reinstate the workman without back wages. This affidavit in this regard of the respective party in this regard be brought on record by first week of either by date they do and place kariba matter by 22nd of June, matter to appear on 26th of June. Yes, all right, yes, rest of the cases.
Next item, the election result has been stated. Even though petitioner union participated in the election.
Tomorrow it will be in the list.
Tomorrow you remind us. Okay?
Right.
You remind us, this is the because ଆମେ କଣ କରିପାରିବୁ 12:30 ପୁଣି ଆଉ ଗୋଟେ ବେଞ୍ଚ ରେ ବସୁଛନ୍ତି ମୋର କିଛି କରେକ୍ସନ୍ସ ରହୁଛି ଜଣିକିଆ ହଉଥାନ୍ତେ କି ମୁଁ କରେକ୍ସନ କଲି ଟାଇପ ହବ ଦସ୍ତଖତ ହବ ହେଲା ପରେ ପୁଣି ସେଠିକି ଯିବ ସିଏ କରୁଛନ୍ତି କିଛି ମୋ ପାଖକୁ ଆସୁଛି it takes some time.
One.
May it please the son of the court. My lord, in this matter, the petitioner seeks a direction to OP number 2 for disposing of the mutation case which she has filed within a stipulated period, my lord. So the mutation case she has filed since 2014.
Yes, 2014 mutation case is pending.
She has purchased the land since 2004, my lord, since running since 17 years.
Unfortunate to note that mutation case 8547 of 2014 is pending at the hand of OP number 2. Considering there is sufficient delay and seems to be there is already unnecessary harassment to the petitioner involved therein. In the disposal of the writ application, this court direct OP number 2 to conclude, to give a lawful conclusion to the mutation case 8547 of 2014, at least working it out within a period of 3 months. Also in the involvement of the party likely to be affected. This order is, however, subject to there is no lawful restriction in proceeding with the mutation case.
Okay.
Item number 2.
Item number 2 is the cover matter. Matters judgment. Will challenge the annex 4. We are permitted to correct the prior part.
Yes, you have examined.
Yes.
You will correct what? Cost title?
Cost.
Cost title?
Prior part.
Okay, counsel for the petitioner brings a request to make necessary correction in the prayer. Considering genuine request, this court permit the petitioner to make handwriting insertion in the prayer portion in court. You know, it for a separate order, order number 2, then order number 3 for the this one. Yes.
Item 24 is a similar matter. Item 24, similar matter. 24.
24. Okay, there also correction is necessary.
Correction.
All right. Intimate kar debe kiye government
Yes,
council. Yes.
Item number 3.
Item number 3, Your Lordship, the petitioner was a successful candidate, returned candidate, elected as Sarpanch Nabrangpur Gram Panchayat in the 2022 elections. Subsequently, his election has been set aside.
What is the cause of action here?
Lordship, cause of action is both the courts below have set aside my election on the ground that I had not disclosed regarding the pendency of the criminal antecedent in the affidavit that was supposed to be provided. Now, Lordship, may kindly come to page 5.
No, what is the cause of action here? What application has been considered or rejected? It is main disposal of the election dispute.
Lordship, main dispute. My election has been set aside.
So your election has been set aside.
Lordship.
So you have challenged that final order.
Lordship.
Okay, then notice has to go. Appeal, what happened?
Appeal also I have lost, Your Lordship.
Appeal also you have lost. Okay, then notice has to go.
Lordship, let the notices go.
Admit call for records.
Lordship.
In election case number, election miscase number 4 of 22 from the file of Civil Judge Junior Division, Nayagarh. Requisites as undertaken. By day after tomorrow. Yes.
Item 4.
May I please your lordship, my lord? In this matter, the petitioner have prayed for a direction that section.
Pardon?
My lord, the petitioner have challenged, have prayed for a direction that section 22 is not applicable to homestead land, my lord. The land in question, my lord, is a Ghoravadi in nature and within the urban area, my lord.
Similar in item number 2. Similar. Item number 2.
Similar to item number 2. Prayer title came to achieve.
Annex 3.
Prayer correction darkar nahi. Okay, similar to prayer correction darkar. Yes, you make necessary correction in the prayer. You don't challenge that order. That's the problem.
We'll make this.
So yes, the prayer item 2 बढ़िया कर दो. Yes. दे दियो file down. Yes.
Item 5.
Yes.
5 in purchase matter.
Not press, madam. Okay, already suspension revoked.
Hmm?
Already suspension revoked. madam.
Already?
Suspension revoked.
Mic ta tikke upro.
Infructuous, madam.
Infructuous.
Not press.
Matter has gone infructuous as claimed by the counsel for petitioner. And dismissed as infructuous. Hmm.
Item 6.
Madam, this is the second petition.
Pardon?
This is the second petition, the second writ petition. Previously, this honorable court had directed to dispose of the petition to the collector and
Rejected.
yeah, rejected. And the thing is that they accept that there is a drought, severe drought, and they have given input subsidy, but they are not prepared to accept that the faulty.
Okay, then you take notice, it has to be considered on their filing counter. Who are you? You are the applicant there.
Again.
Jai Krishna Bhagar.
Again.
Okay, all right, take issue notice on the question of admission. Notice accordingly, counter if any be filed within 3 weeks of the service of copy. Yes.
Item 7.
My lord, item 7, before opening the brief.
Pardon?
Before opening the brief, my lord, your lordship may pardon me, there is a mistake in the prayer portion that instead of annex.
You want to make necessary correction?
No, correction, instead of annexure 8, annexure 11 has been there. My lord, my in case before your lordship is that I wanted to establish a
Instead of annexure?
8, annexure 11 lekha is.
Okay, it has to be annexure 8. Then date?
That my
Date
lord,
will also be changed?
yes, but in the throughout the in the petition there is nothing wrong.
Okay, all right, only prayer portion.
Prayer portion that annexure
Okay,
11.
say
My
oral
lord-
submission, right? Oral submission, they permitted to bring necessary correction.
My lord, my case before your lordship is that, my lord, I want to establish a
Slow hochi kahinki? Yes. Who is that in computer? Why voice is remaining slow?
Subuni,
No.
bilkul subuni. Ebe subila.
Nahi, subuchi, kintu very low hochi. Yes.
My lord, I want to establish a warehouse replaced unit at Paradip. For the last 3 years, I am running. One plea or other, it is being rejected. And this time, your lordship may kindly turn to annexure 8. Annexure 8 at page 38. On the ground that I didn't attend the meeting and also didn't file the queries, didn't answer the queries as asked by them.
Now, which item? The first item?
Uh,
Agenda number 3?
Agenda number, my lord, your lordship may kindly see the member secretary so and so apprised the committee
Yes.
that earlier one Go Swift proposal of Messrs. Kalinga warehouse of Go Swift proposal number so and so, so and so, so and so. My lord, towards the last, your lordship may kindly see. Messrs. Kalinga warehouse and replaced number so and so dated 31/1/23 was received. And the unit was asked to comply the query raised by the DIC Jagatsinghpur on 2/2/23. In this connection, the unit has neither responded the aforesaid online query nor attended the aforesaid scheduled meeting of the DLFC Jagatsinghpur held on 2/3/2023 to represent their views feedback before the committee, even though virtual mode. Hence, in view of the above, the committee on so and so held on 2/3 so and so decided to place the proposal as it is with the above observation before the so and so. Further, the member secretary so and so apprised the committee that meanwhile the unit has responded the query at the online GoSuite portal to mislead only. However, no document has been submitted by the unit in support to online query.
Okay, therefore they have rejected your claim.
Then your lordship may kindly turn to page 40. Page 40. My lord, date 17 March 2023.
Yes.
Lordship,
Query is 17 March.
My lord, Konark Warehouse gmail.com on 17 March 2023,
Yes.
17 to 2006. Department has raised the queries on the application for DIC of
To
ministers.
reply the queries
Yeah.
within 60 days.
Yes,
Hmm.
60 days, my lord, from 17 March.
Issue definitely.
Yes,
Hmm.
but it has been done on 15th March, on 10th March, they have decided to reject it. My lord, right, my submission before your lordship is that thereafter I have also made a representation order annexure 9. And that apart also, the lordship may kindly turn to page.
Yes, yes, you take instruction. If the query by annexure 10 was sought for on 17 March 2023, giving 60 working days time, then what was the urgency in taking up the issue on 10 March?
No, 15th March.
Huh?
15th March, 10th March.
Yes, this decision is taken on 15 March.
Yes.
You could have waited.
My lord, your lordship may kindly.
But even assuming, suppose it has been decided early, but they have taken into account your objection.
But my lord, no. Your lordship may kindly turn to annexure 11, page 41.
Hmm.
The letter to all the collector by the principal secretary MSME. As you must aware, may I read, my lord? As you must aware, MSME plays a very significant role in the economic development of the state, besides contributing a lot of tax revenue of the state. They also employ a large number of people in gainful.
What is the activity involved here?
My lord, involved here, they want to recycle the plastics. So that it will be betterment for the ecosystem.
It can be utilized otherwise.
Yes. Utilized, and that apart also, Director of Industry has also recommended.
Take notice. Let them take.
May I pray, your lordship may dispose it of, directing them to consider it, keeping in view the recommendation made under Annexure 7 by the Director of Industry.
No, that will be, then I am to interfere in the order.
Yes.
I am to interfere in the order. Let us give them scope of hearing.
Then
You sought copy, extra copy.
I have sought a copy. They are not giving us.
Have you got instruction? What to do? Have you got instruction?
No.
Then have a discussion with your party. Can the matter be reopened? Intention is very good. And queries, what query you have made? See, what is the query there? What is the query you see? Department has raised queries on the application for DIC. Applicant is requested to reply the query. Where is that query?
Queries, my lord, I have
So query, what query was it attached to this?
Queries, they have not stated anything.
Where is your plea that there is no query accompanied annexure 10?
My lord, that I have stated in my petition.
Yes, which para? It must be pleading on annexure 10.
Yes, annexure 10.
Come to para 10.
Yes.
Para 9 you have disclosed on this notice.
And that Industry Principal Secretary so-and-so issued instruction to all collectors stating therein that for promotion of MSME intervention is required to district level, since MSME plays a significant role in economic development of the state of government of Orissa, giving utmost importance for promotion of development of MSME so that they become the backbone of the state's economy. Further, the said later it was reflected to hold monthly grievance sale to MSME on a fixed date in the name of.
No, you have not stated anywhere that this did not accompany the queries.
No queries, my lord. I have stated that I have answered the queries.
So you are in receipt of queries.
Yes.
Then where is that query?
That query, I will, my lord. I have stated. Your lordship may kindly turn to. My lord, to the chairman, annexure 3. I have clarification of your queries. Annexure 3, page 21.
Why are you not bringing the queries?
My lord,
so that we can know what was the level of queries, so that.
Page 21, your lordship.
Page 21.
Yes. We are giving below point-wise answer to the document to comply in support of our proposal. My maiden name is changed after my marriage. I also short name as RM Mahapatra while signing my name in report so and so. The financial parameter like cost of plant machinery have been amended in so and so, so and so. Number, no proposed employment potential goes with proposal is also.
Mr. Sahu,
Yes, sir.
see, even though your authority has said to have considered the response to the query submitted subsequently, but there is no dealing with anything.
Yes, there is a finding.
Come to that page 38 or 37.
38.
Further, the member secretary DCWC apprised the committee that meanwhile the unit has responded the query at the office online to mislead only. What is this? So let us remind the matter.
And that apart, Lordship may kindly turn to Annexure 7, page 35. That will also clarify many things. It is page 35, Annexure 7,
Yes.
Director of Industries. It is, my lord, on the right side. It is understood that the applicant has proposed to set up a modern recycling plant, which is one of the 10 common infrastructure facilities needed in park under the plastic park scheme of the Government of India. Further, the applicant proposes
Who has passed this order?
This order has been passed by the Director of Chief Executive Officer, Paradip Plastic Park.
So you reconsider, you enter into reconsideration process taking into all these things. Had the submission of Mrs. Das, learned counsel for the prisoner and
Mrs. Jenna.
Learned-
Mrs. Jenna.
Jenna, sorry. ଆଜି ଏବେ ଆସିଲା ବେଳେ ପଢିକିରି ଆସିଲି collegiate 1973. Okay, so I could remind my friend's name. So in the process. And that book has contained my elder brother's photo. 73 batch, he was in 73 batch. So, recollection of history. Okay, Mrs. Jenna, Petition involved the following prayer. Principal challenge involving the writ application appears to be alleged illegal consideration of the case of the petitioner. এটা ଆପଣଙ୍କର agenda 3 ତ? ନାଇଁ ତ? ଆପଣଙ୍କର ଏଟା agenda ଟା କେତେ?
Agenda 3 subclause 2.
Subclause 2.
Agenda 3 Roman 2.
2.
Roman 2. Taking this code to the request of the authority for answer to the queries raised and ascertain Mrs. Jenna taking again this code to Annexure 3 intended there has been submission of response to the queries sought for. It is again taking this code to the development through recommendation through Annexure 7. Mrs. Jenna also attempted to convince the court that there has been already a recommendation by competent authority as marked in right-hand column, serial number 1, page 35. It is next taking this court to the discussion on the consideration of the case of the petitioner herein, appearing at page 38. Petitioner has a serious allegation that when the first part discussion indicates petitioner did not have the response to the queries. In the subsequent para, there is abrupt reaching with the conclusion, merely stating that even though there is a response to the query at the online GoSuite portal, but it is simply to mislead the authority. It is in the above background. Mrs. Jenna claims there has been mechanical disposal of the issue involved therein. The SAHOO Learned Council ASC, however, in opposition to the allegation of the petitioner, again on reading of the observation part, page 38, for the reason assigned therein, attempted to satisfy the rejection of the claim of the petitioner. ये जो page 38 पर है, there must be another page. अपन पूरा page भी दे ही ना थी.
Page 38 ପରେ
Yes, 38 stroke है कि 37 लिखा है जी.
ना এটা দেখুনাহাନ୍ତି ଚାଲିଛି in support of the online query raised. Hence, after সেটা তার
Where is that page?
সেটা পেজটা উল্টে ଯାଇଛି 37 38 এপর সেপট ହେଇଯାଇଛି.
Oh yes, acha. Okay. Yes, page उल्टी ଯାଇଛି actually. Correction करा ହେଇଛି ଆମେ pencil ରେ କେତେବେଳେ କରିଛୁ ମୁଁ ହିଁ କରିଛି ବୋଧେ ତାକୁ ତଳ ଉପରେ ହେଇଯାଇଛି page ଟା.
ଓହୋ.
Mean this court in consideration of the rival contentions of the parties finds undisputedly petitioner has responded to the queries by Danister 3. This apart, there also appears there is a recommendation in favor of the petitioner by page 35, first para right hand column, PP was it, running as follows. It is that this is taking into account the discussion and the observation, final observation. In the impugned order annexure 8, this court find there has been absolute non-consideration of the there is not only no dealing with the response of the petitioner to the queries, there has been no taking into account the recommendation of the competent authority by Annexure 7, as taken note here in above. Considering the impugned order involves a mechanical rejection, this court, setting aside the decision against the petitioner involving agenda number 3 Roman 2, impugned herein, set aside the same, remit the matter back again to the collector cum DM cum chairperson, comma DSWCA Jagatsinghpur for reconsideration of the matter, of course taking into account the recommendation at Annexure 7 as well as the objection of the petitioner by Annexure 3
and also 11.
by completing the entire reconsideration process within a period of 1 month from the date of communication of order.
From the date of production of certified copy. Annexure 11 টা भी Annexure 11 টা भी था.
Okay, the decision process may also include the development through annexure, the instruction to all collectors by the principal secretary by Annexure 11.
Obliged. Urgent copy of your lordships. Urgent copy of your lordships.
Urgent copy aji पाइबेनी.
नहीं आज को पाइबिनी.
Type हबो दीटा बेंच रो मैटर
नहीं,
टाइप
ठीक
करछंती टाइप कला परे करेक्शन करिवि.
आज्ञा.
ଆଉ କାହିଁକି ଶୁଣନ୍ତୁ ଆପଣ କାହିଁକି ସବୁ ଆଉ urgent copy କହୁଛନ୍ତି, that concept is gone.
नहीं नहीं ଆମେ ଆମର କରିକି ନଉଛୁ.
ନାଇଁ ଆପଣ copy ପାଇବେନି. We are closing that supply copy. ଆମେ ପୁରା system କରିଦେଲୁ ଆକୁ upload କରିବୁ with digitized signature of our secretary.
ବର୍ତ୍ତମାନ ପାଇଁ ଥାଉ ଆମେ ଆମର ଥାଉ ଯେ ତାପରେ
Receive କରୁଛନ୍ତି ସେମାନେ copy application. But that will be ending very soon. Copy section will be totally closed. ଆମେ ଆମର digitization signature ର secretary ର ଯିବ copy ଆପଣ ସେଇଟା download କରି
ସେ
true
କୋଉ
copy
ଦିନ
ଦେବେ.
ପୁଣି ଡାଉନଲୋଡ ହଉନି କଣ ହଉନି ସେତେବେଳେ ଆମେ ହଇରାଣ ହବୁ. ସେତେବେଳେ କିଏ କଣ କରିବ?
All right, now system is changing day by day.
Obliged.
Okay, next.
Item 8.
Item 8, my lord. Similar matter one, yesterday was item number 7.
Okay, mic को raise करो तो mic raise करी कौन Yes, he has given a copy to you. Out a copy to thank you and the cover will receive for the Kaya copy kain. Ataku debe, amuku debe, ketole debe. Kain out dita copy kori anunante kasum. Abo representation disposal.
Demarcation case.
Demarcation posting. No, ସେଥିରେ ବି copy order ଦେଖାଉଛି. Demarcation case 195/22. 195/22.
Yes, sir. 22 or 23 also, page 13, 23.
Case number kete 195/22.
195/582.
देखो এটা देखिए करेगा ना. Yes, same thing. But however involving no party likely to be affected. अच्छी सेशन ठीक है.
Item 9.
On item 9, my lord, the petitioner.
Subuni Jama.
My lord, item 9.
Yes.
My lord, the petitioner is the my lord, registered owner. That is Sundargarh district. Boss owner syndicate, my lord. In earlier occasion, this association has been approached this honorable court, my lord. That is in WPC number 8632 of 2014, where after disposing that representation, the authority, that is Sundargarh municipality, has been allotted a place. But there is no specific place has been allotted, and the place which they are indicating, my lord, that is encroached by another person, my lord. That is the whole grievance. To that effect, my lord, I have made representation before the Sundargarh municipality chairman in page 27, my lord.
This
Representation dated 16/4/2022, my
This representation appears to be in second round of litigation. In the first round of litigation, in the disposal of WPC 8630 of 2014, the single bench of this court directed OP number 1 and 2 therein to consider and dispose the representation of the petitioner. It is based on such, it is claimed based on such direction, though there has been allotment of space inside bus terminal Lohura Depot by Daneswar 2,
my lord,
and consequential deposit is also made by Daneswar 3. The petitioner find difficulty in finding the place. It is for such difficulty, it appears, petitioner has already made a request to the chairman.
That is
Have question, chairman na executive officer?
to the executive officer, my lord, page 27. Page 27, my lord. Running page 27. That is representation dated 16/4.
Submitted a representation to the for demarcation of the space allotted, demarcation and identification of the space allotted inside the bus terminal by page 27.
And 26 also, my lord.
At page 26, similar request is also made to chairman. Okay, this court in the disposal of writ petition, observe in the event the OP number, executive officer OP kete hichi?
That is opposite party number, my lord. 3, my lord. Sorry, 2.
2,
my lord.
OP number 2 is directed to give a lawful disposal to the request of the petitioner by page 26 and 27 herein. Involved in the involvement of the petitioner and also completing such exercise within a period of 15 days of receipt of copy of order, along with the copy of petition. Yes.
Obligation.
Item 10. May I please your lordship, my lord. I am the winning candidate, my lord. I am the ward number 11. I am challenging the order under annexure 5, my lord. Order 6, rule 7 petition was allowed, my lord.
What is the application rejected? Order 6, rule 17.
Allowed, my lord.
Allowed.
Allowed.
By whom? By return candidate or defeated candidate?
I am the winning candidate, my lord.
Oh, who has moved that application order?
The defeated candidate, my lord.
Huh?
Defeated candidate.
By the election petitioner, defeated candidate?
Yes, my lord. That is to file after 9 months, my lord. This petition has been filed after 9 months. Election was declared on February 22.
You are the return candidate?
Yes, my lord.
You are the return candidate. What was the amendment? Let us see.
At page 27, my lord.
Amendment of page 27 rachi.
Scheduled amendment, yes, my lord. Symbol was not distributed as per Odisha alphabetical order.
Just 1 minute. Page 27, 20.
Annex of
Yes,
3,
26 left.
Scheduled amendment, my lord.
Yes.
That at the end of para
ଟିକେ mic ତଳକୁ କରନ୍ତୁ. Yes.
That at the end of para 2 of the election petition, the following sentences: the name of the opposite party number 1 is SK Yunus, as the name of the petitioner is Digvijay, and the name of the opposite party is Yunus, and SK is a title. The symbol was not distributed as per Odia alphabetical order under the provision of section 17 and 22 of Odisha Gram Panchayat Relation Rules 1960 be added, my lord. These were not never the ground of challenge, my lord, in the petition, election petition.
Issue notice on the question of admission. Fixing short returnable date. Madam. Yes, place the matter immediately after appearance of the contesting opposite party. In this case, a notice as above. As an interim, this court direct. There should not be conclusion of the evidence without leave of the court.
Item 11. Ma'am, please.
Yes.
The matter relates to illegal demand of water tax by the revenue authorities in non-irrigated land ownership. Involving similar issue ownership and writ application is pending for this honorable court. I'm supplying the copy of this honorable.
So 4 is still pending. Page 23.
That is a previous representation of lordship.
Then
so far the earlier writ application pending lordship by the other villagers. This honorable court issue notice and interim order has been passed. I am supplying the copy of lordship.
Then why a second writ petition?
No, this is the present petition was not the petition in that writ
May not
application.
be, but you can join there as intervener. Why a fresh writ petition again? Why another interim order?
Yes,
No, you may join there. If you support the cause of the petitioner, you are supporting the
similar
cause of
issue,
the
similar
petitioner, then
issue,
you
yes,
may
sir.
intervene just. If he lacks in argument, you may support him. Why next further writ petition?
The demand I have also
Withdraw this.
paid the
That's
lot of
खाली
notice
उनका
out tag out.
खाली काम करो. On the self-same issue, it appears there is already. But this writ petition was in 2016.
Yes, sir, lordship. 2006.
That is still pending.
Yes, sir, lordship.
What is the stay effect of this stay?
Stay lordship, that is there. No course against the petition regarding demand.
Now,
of
what is the action here?
the here action they have
Dalapara notice.
Yes, sir. They have demanded. I have also paid a little bit. This for the year 2022 and 23.
ଜଳକର କେତେ ଟଙ୍କା ମାଗୁଥିବେ ଯେ ଆପଣ
5,528 ଟଙ୍କା ଏଇ ବର୍ଷ ନେଇଛନ୍ତି ମୋ ଠାରୁ
5,500?
ଆଜ୍ଞା ମୁଁ ଦେଇଛି ଆନେସର 5 page 27 ଲର୍ସିପ ପାଇଁ ଲିସି
ନାଇଁ ମାନେ ଏଇଟା କଣ ବାର୍ଷିକ ଜଳକର ନା?
ଆଜ୍ଞା ଆଜ୍ଞା
ଆପଣ ବିଲକୁ ପାଣି ଦେବେ ବୋଲି?
କିନ୍ତୁ ଆମକୁ ଦଉନାହାନ୍ତି ଆନେସର 2 page 11 ଲର୍ସିପ ପାଇଁ ଲିସି there is a joint verification. And so it is observed that after connection of a direct CADA or field channel to the above Serpur village can be accessed. That are the report of lordship. Aji porjanto CADA kichi connection ଦେଇନାହାନ୍ତି କିନ୍ତୁ ପଇସା ନେଇ ଚାଲିଛନ୍ତି.
ନାଇଁ ଆପଣ ଗାଁ ବାଲା ପୁରା ବନ୍ଦ କରି ଦଉନାହାନ୍ତି ବୋରୱେଲ କରିଦେଇକିରି?
ଆମ ଗାଁକୁ ନାହିଁ କିଛି
କି ଦରକାର ନାହିଁ ଆପଣ ବୋରୱେଲ କରି ପାଣି ନଉନାହାନ୍ତି?
ଆମେ ତ ସେମିତି ୟୁଜ କରୁଛୁ କିନ୍ତୁ ସେମାନେ ଡିମାଣ୍ଡ କରୁଛନ୍ତି
ବନ୍ଦ କରିଦିଅନ୍ତୁ ଆପଣଙ୍କର ଜମା ନା ନଳ ରହିବ ନା ଆମକୁ ଦବାକୁ ପଡିବ ଟିକସ?
In fact ନାହିଁ that is the issue involved lordship.
ସେମାନେ admit କରୁଛନ୍ତି ଯେ
Yes,
our
what
area
is
is
going on?
non-irrigated.
ଚାଷୀକୁ ପାଣି ଦେବେ ଆପଣ ତାଙ୍କଠୁ ମାସକୁ ବର୍ଷକୁ 5,000 ଟଙ୍କା ନେବେ। ସହର ବାଲାଙ୍କଠୁ ପାଣି ପିଇବା ପାଇଁ ନଉଛନ୍ତି 5,000 ଟଙ୍କା ଆଗ ମାସକୁ ବର୍ଷକୁ।
ଏକର ଏକର ଲ୍ୟାଣ୍ଡ
ହେଇପାରେ।
ଲ୍ୟାଣ୍ଡ ଦେଖେଇଛନ୍ତି।
ପାଣି is a serious resource for agriculture. You are duty bound to provide water. ଆପଣ ପରା ଆମ ଟିକସ ପଇସାରେ ନଳା ତିଆରି କରୁଛନ୍ତି, କେନାଲ ତିଆରି କରୁଛନ୍ତି, ତାଙ୍କୁ ପାଣି ଦେବେ ବୋଲି ପୁଣି ତାଙ୍କଠୁ କଣ ନେଇଯାଉଛି?
ଏ ଯୋଉ ନୋଟିସ ଗୁଡାକ ସବୁ ଫାଇଲ କରିଛନ୍ତି ସବୁ ଯାକ 2016 ର।
ସେତେବେଳେ ହେଇଥିଲା, ସେତେବେଳେ ଅଲଗା ମାନେ
ହେଇପାରେ। ସବୁ ଷ୍ଟେ କରି ରଖିଦିଅ ଦେଖିବ।
Demand notice
There should not be any coercive action against the petitioner. Same order କରିଦିଅ ଯାଅ। ଚାଷୀ ବଞ୍ଚୁ, ଚାଷୀ ବଞ୍ଚିଲେ ଦେଶ ବଞ୍ଚିବ। ଆପଣ ଇଆଡେ ଚାଷୀଙ୍କ ଆକାଉଣ୍ଟକୁ ଟଙ୍କା ପଠେଇକିରି ଫଟୋ ବାହାର କରୁଛନ୍ତି ପ୍ରତି 4 ମାସରେ। ଦୟା କରୁଛନ୍ତି ବୋଲି ଦେଖଉଛନ୍ତି। ଆପଣ କାହିଁ ସବୁ ପଞ୍ଚାୟତରେ ତ ଭୋଟ କୁଢେଇ ପକଉଛନ୍ତି। ମାଉଁସ ଭୋଜି 3 ଦିନ ଦେଇଦେଲେ ବୋଲି ଭୋଟ କୁଢା ହେଇଯାଉଛି, କାହିଁ ସେତେବେଳେ ଏଗୁଡାକ ତ କରୁନାହାନ୍ତି। Yes.
My lord, the petitioner has prayed before the Tahsildar of Bahanaga, Baleswar for demarcation of his land property, submitting his application with the relevant document, that is RSD, ROR and fill of form. But the Tahsildar has not taken steps to.
You have a demarcation proceeding pending.
Yes, my lord, demarcation proceeding pending, but a demarcation case number bhi karinahanti.
Where is your demarcation application?
Application annexure 6 in the application form.
Annexure 6 cannot be an application for demarcation. There is a format.
Yes,
Stamp देबे आपण payment करिवे।
Again.
आ ई सब कोन? I permit you to bring the application in proper format.
Yes, my lord.
Yes. Even though attempt is made through Annexure 6 to satisfy that there has been already an application for demarcation by the petitioner. On bare looking to the Annexure 6, this court finds representation on work involving a demarcation request as there is prescribed procedure and required fees necessary in commanding such request. Okay, learned counsel for the petitioner wants to withdraw the writ application in order to bring in the request herein through appropriate format. In the event request for demarcation is brought in appropriate format by the petitioner, at least within 7 days hence, same shall be given lawful disposal, however involving the boundary tenants therein.
Item 13. My lord, I may plead your lordship. My lord, by the annexure to my case may be accepted to initiate.
You have a mutation case pending?
No mutation case, it is Survey Settlement Act. Settlement proceeding is going on for that village.
Settlement operation going on?
Going on for that village.
Read court came direction dava.
I prefer a case under section 12 of the Act, of the Survey Settlement Act. And the concerned authority has not accepted my case by the annexure 2.
Now, if a settlement operation in the area going on, what is the occasion for your coming to court?
He is not accept. He refused to accept my petition.
Provided the petition is entertainable.
Section 12 is there. Section 12 is there to accept my petition.
You have purchased the land by way of sold it.
By way of sold it.
But at the same time, you say settlement operation is going on, so you can place that in the settlement before the settlement officer there or ASO, whosoever there. What
is my lord? Opposite party number 3 has vested power to receive the case, but he has not refused.
No, that's a general situation. Not in the situation available here. Here is a situation, village is facing a settlement operation.
My lord.
So you can go there and put up your application before the authorities.
I have gone there and put up my application, but he refused to accept.
Where
this
is that application?
That is Annex 2, my lord.
No, Annex 2 is to additional sub-collector. Additional
Additional
sub-collector.
sub-collector, now the amendment has been done and additional sub-collector is receiving the application. That is case of
Okay,
Jashpur.
section 12, section 12 is, has the section 12 stage arrived?
No. Final,
Survey settlement.
final publication before final publication.
So before final publication, he can simply go and place his case.
Yes.
Sir, this is a cell deed, so therefore in the operation, my name may be recorded.
May be recorded.
সেটা ASO পাখে হবো।
ASO পাখে হবো। Who is undertaking the settlement operation?
Now the additional sub-collector.
No, additional sub-collector kept settlement operation korandani.
He has best under this to initiate an appeal.
No, section 12 itself says,
yes,
on the draft publication, you may raise your objection to the assistant settlement officer.
Now the amendment has been done. Amendment has been done.
Can amendment দেখান?
এইটা স্যার
দেখান তো। বই তো ମୁଁ ଧରିଛି କୋଉ ମସିହାରେ এটা 2018 ବହି ଅଛି। এটা କେବେର ବହି? 22 ରେ section 12 ଦେଖିଲେ preliminary publication of draft record.
Yes. When a draft record of right has been prepared.
ठीक है, माइक क्या करे?
Assistant settlement officer shall publish the same in the prescribed manner and for the prescribed period and shall receive and consider any objections which may be made to any entry therein and any objection that from during the period of
when the amendment.
I have also made the opposite party to in my
No, your making party here doesn't help you. Your annexure 2 shows it is directed to somebody else.
Additional sub-collector. 12B. 12B.
Final publication.
Sabu by assistant settlement officer.
Again.
12B, sir, my lord, 12B does not refer to assistant settlement officer.
Yes.
So far,
12B also refer.
12 objection case is concerned, so assistant settlement has the power.
Appeal may lie to additional sub-collector.
No, what I'm explaining, 12A is there. There is appeal provision provided the party is not satisfied with the.
Definitely.
ASO like
12A. Stage has not come.
12B final
Yes, you withdraw and find out appropriate procedure.
My lord, he is not receiving the case. That
Even
is my
though
question.
there is
My
allegation
case
that
may be received.
there is no receiving of the complaint of the petitioner, complaint oblique objection of the petitioner by the authority under section 12 of the OSS Act. On perusal of annexure 2, this court find petitioner is raising his objection before additional sub-collectors as per. For the matter in the stage of section 12 of the Act, petitioner is required to make his endeavor before the ASO. This court records the statement of learned counsel for the petitioner that the settlement operation is still on, in the locality is still on. In this circumstance, this court find the submission of the objection or complaint by petitioner by annexure 2 is not entertainable. This court find no substance in the writ application which is dismissed accordingly. Yes, next.
My lord, in this case, my lord.
Item 14.
In this case, my lord, demarcation application under annexure 1 is pending before the opposite one of 3.
ये 2017 ରୁ କାହିଁ pending
नहीं अपन ଟିକେ ଦେଖିଲେ annexure last annexure ଟା ଟିକେ ଦେଖନ୍ତୁ ସେ ତାଙ୍କ annexure 3 page 10
yes
ସେ ପଇସା deposit just a minute ପଇସା deposit କଲା ପରେ date fix ହେଇଥିଲା that thereafter do not know probably is not satisfied with the demarcation ସେଥିଲାଗି ରିଟ୍ ଫାଇଲ କରିଛନ୍ତି opposite party ବି ଅଛନ୍ତି ଅହଲ୍ୟା ଦାସ ତାଙ୍କୁ ପକ୍ଷ ବି ସେ କରିଛନ୍ତି of course
ନାଇଁ କ୍ୱେଶ୍ଚନ ହଉଛି ସରିନି ବୋଲି ସେ ଆଲିଗେସନ
କରୁଛନ୍ତି ତାହେଲେ ଆମେ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ନେଇଯିବାଟା ବେଟର ହବ ଯଦି ନ କରୁଛୁ ତାହେଲେ
ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ମୁଁ କହୁଛି ଯଦି ପେଣ୍ଡିଂ ଅଛି
ତାହେଲେ ହଁ ତାହେଲେ ଠିକ ଅଛି
Fine.
Sure.
Yes, had the submission of land counsel for the petitioner through annexure 3 there is serious allegation of non-disposal of a demarcation case 20/17. It is also alleged in spite of a notice for undertaking the required exercise on 29/5/18. There has been no outcome in such proceeding. Considering unnecessary pendency of a demarcation proceeding for over 6 years, this court in the disposal of the writ application observed in the event demarcation case 20/17 is still pending. Same should be given lawful disposal, at least working it out within a period of 3 months, and in the involvement of the boundary tenants. This order will be worked out subject to there is no lawful obstruction by way of any interim order obstructing such demarcation by any competent court.
Time.
Item 15, mailers. The petitioner challenging the rejection of the mutation appeal mailer by the sub-collector.
Rejection of mutation appeal.
Yes, my lord.
You are the appellant there or respondent? You are the appellant.
Yes. On the ground. There is annex
So,
3.
mutation having been allowed, you went in appeal.
Yes.
What is your case?
Here is my lord. Annex 3 is the mutation allowed and recorded in my name, but in the plot, total area is 206 decimal. 205.
Mic around.
205 decimal was settled, my lord. Only 1 decimal in remark column, annex 3, page number 18, my lord. That is behind Kharif Sutre Dakhal Tirnath Mahapatra. Name was entered by the Tahsildar, which was challenged. That order was challenged.
How to get over in a mutation appeal? Why are you not going in section 15B?
15B process was over, my lord. That was process was over. Annexure 1.
You have attempted through 15B.
Yes, in the year that order we made on page 12, my lord.
This is illegal. This is illegal. He should have taken a decision on his own. He can't direct the Tahsildar. Now Tahsildar was directed and he has also undertaken the exercise.
Yes.
It went against you.
Yes.
Ultimately, you will not succeed in these proceedings. In the case of any dire necessity, you may go for civil proceeding even. Notice niyantu dekhiwa young pillars. You should notice on the question of admission or otherwise. Refugees as undertaken by day after tomorrow.
Item 16.
May I please your lordship, I am appealing for virtual mode.
Yes.
Your lordship, this is the petitioners were the appellants in Annex 1, that is the mutation appeal number 5 of 2020, and it was allowed by the sub-collector. Thereafter, your lordship may kindly turn to page number 5, para 6. The allegation is, on being asked, the opposite parties are playing they are exchanging their liabilities. The opposite party 2 alleges that he has not yet received the case record from opposite party number 1, whereas opposite party number 1 has said that his staff has already sent the case record. Now, your lordship, this petition is for the direction to the OP number 2 to carry out the order passed by the OP number 1.
Yes, Mr. Ghosh. There is appeal order already. For the purpose of record sending or record receipt, why should a party be suppressed?
Yes, yes.
At the submission of Sri Purohit Pra?
No, Padjoshi.
Padjoshi, sorry, Padjoshi. Sri Padjoshi from Kalahandi on DC. Through the pleadings, there is serious allegation that even after the order of the competent authority in the disposal of
Page 13.
Miscellaneous appeal.
Page 13 টা দেখুন তো ଟିକେ last portion টা page 13 1-3
Here.
The sentence hence this mutation appeal is allowed by setting aside the order dated so and so in mutation case number so and so passed by Tahsildar Kolahandi is directed to dispose of the mutation case. She author reopen করছে the mutation case.
So therefore mutation
Case has to be concluded.
Must be concluded.
Yes.
Yes. Even though the mutation appeal has been allowed in the setting aside of the order dated 27/12/19 in mutation case 519 of 16, the Tahsildar Kolahandi is still sitting over the matter and not giving a lawful disposal to the remand mutation proceeding. To the pleading petitioner alleges the proceeding is kept pending only on the premises of non-receipt of records. Petitioner alleges he should not be suffering on account of delay in the transmission of record. This court considered the yes and observe once the remand proceeding, once there is recommencement of the mutation case by virtue of a remand order, it is the responsibility of the appellate authority to remit back the case record forthwith to the Tahsildar Kolahandi for his appropriate discharge in the final outcome in mutation case number 519 of 16. It is while disapproving the conduct of the authorities, public authorities involved herein, this court in the disposal of the writ application directs the appellate authority OP number
1, Your Lordship.
OP number 1. In the event the case records involving mutation case so and so is yet to be transmitted to the Tahsildar Bhawanipatna, shall transmit the case records taking help of a special messenger at its own cost. At its own cost and without involvement of any public fund from public access. So as to reach the Tahsildar Bhawanipatna by 15th of May. In such event, the Tahsildar is directed to complete his remand exercise in the mutation case number so and so, showing a lawful outcome within a further period of 2 months, but however involving the party likely to be affected. ये सेटा हातुर खर्च करिकी स्पेशल मेसेंजर पठो सेही ऑफिस रे तो तळे थिबो सब कलेक्टर ऑफिस एंड तहसीलदार ऑफिस व्हाट इज द डिस्टेंस
Around 100 meters.
100 meters.
गोटा कैंपस भितर हेति
से कागज पकई दो ता देरे 100 टका खर्च होला बोली
पियन को पठेगिरी देकी सबमिट करी आसिया कथा
100 मीटर रे मध्य फाइल टा जाई परनी 6 मास
गोटे कलेक्टरेट रो गोटे कैंपस भितर ही
थिबो.
Your Lordship, 17 and 18 are the same matter. Are the similar matter?
Okay, same order of
item
17 also same allegation. देखो तो केयरफुल रहंतु एगुडा को सब भिसी हला जाय जाय सेटु रीड फाइल हलानी
Item 18, Your Lordship.
आ ये भलो करचंदी पार्जुसियो पूरा एकदम पळेले बेडिंग बुस्तरा सब धरि कि सेठी पळेले.
Item 18.
भलो लाइब्रेरी करी गाइड करंतु क्लाइंट को प्रॉपर्ली हला.
Yes, sir.
हां. Yes, item 18 again your case.
Yes, Your Lordship. Similar matter.
Similar.
Yes, yes.
एवढे कसं तीनटा को सिमिलर अछि. Okay.
Yes, Your Lordship.
All right.
Item 19.
By pleasure, Lordship.
But the petitioner's limited prayer to dispose of the mutation case, page 17 annex.
कौन मिस्टर घोष ये सब कौन सबुदिन एमती आसिला म्यूटेशन केस डिस्पोज होनी आमे हाईकोर्ट रे बसिबु क्याडे सी सब बसचंदी एठी से आश्चर्य होतबे आज्ञा दिन जाक इथिरे आकर जाउची
जो केसटा शुनानी हवा कथा ता पे समय हो
डकई दोची जीए सेक्रेटरी को आउथरे
ना हम लिख विल टेक स्टेप्स जितना हो
नेक्स्ट वीक रे जीए सेक्रेटरी को डकई देबी
जदि एभली इंस्टेंस
why should high court sit on these matters demarcation सरलानी म्यूटेशन सरलानी
पुनी आइन गोटे भी आसीबो ओबिसा पब्लिक सर्विसेज जो एक्ट जो अछि अनलेस यू
तादर
कंप्लीट
की जाउ नांती
2012 रू आसिलान से एक्ट
केही जाउ नांती ता अर्थ नुहे जे से माने सिटिंग ओवर रहिबे considering limited request ला
2022 रो के
directed to be disposed of within 3 months 2 months but however involving party likely to be affected.
Item 20.
आपण कहीं ये केस करचंदी जूनियर रखना जे आपण पा 15 वर्ष ऊपर उकिला थिलानी
मोर जूनियर के ना
जूनियर रखना दी हैं आपण रखिया कथा ना जोडी तीनटा जूनियर रखिबे ताले ग्रो करिवे ना नले आपण सब जदी करिवे किन दो
ना हमें मैडम महापात्र को सुनबे कोच सब जे से त हम भी सीनियर से किंतु काग रखना दे हमको भी रखना
महापात्र आउटगोइंग हेलेनी तणु रखिबे न रखिबे अलग कथा पानी
पकड़ जति काम हो तो का पकड़
किला केते वर्ष होला
2004 रो
हैं
2004 रो
माने डिकोडी पाखेलानी डिकोडी पाखेलानी
चारिटा इलेक्शन टेंडर सुरिया बसलेनी
आउ yes yes all right
oblige
Item 20.
May I please, my lord?
Yes.
My lord, here, my lord, mutation appeal was allowed in favor of the petitioner and pro forma opposite party. But as per the direction given by the learned sub-collector, the last portion of the order under Annex 3, your lordship.
Yes.
That the Tahsildar Patna is directed to revert back the land property involved in this case to its original.
Page kete?
Page
16,
16, your lordship.
14 मार्च से ऑर्डर पास हिच
Yes, yes. पढ़ले
Accordingly, appeal is allowed and the order passed by the learned court is set aside. The Tahsildar Patna is directed to revert back the landed property involved in this case to its original record of right.
appeal.
Yes, your lordship. But the Tahsildar has not acted upon and
tapore read thibo.
Again?
Have you found out any read petition must have been preferred?
ना आगुरु गोटे रिट फाइल हेतिला
ना नहीं ई केस रे दी ऑपोजिट प्राइवेट ऑपोजिट पार्टी अछन ना नहीं
आगे ओपी नंबर 6
so he must have come in a read petition pending here verify करछन दिन ना नहीं
आगे वेरीफाई करतली फाइल करना दी
कोर्ट सर्टिफिकेट देछन नो रिट इज पेंडिंग इन्वॉल्विंग सच काली के आसु देखो
नहीं देइजन सर्टिफिकेट देइजती बट नॉट
देइथिले भी देखि नथिबे
से ठीक है देखि तो
ना because we have prepared a caveat petition caveat आगे फाइल हेतिला present petitioner has prepared a caveat
यार सर्टिफिकेट कॉपी काई ये जो ऑर्डर रा सर्टिफिकेट कॉपी काई
ऑर्डर रो सर्टिफाई कॉपीटा
एटा व्हाट आई सजेस्ट एटा लाइव करू थाउ यू लॉर्डशिप में पास डायरेक्शन जे जदी एटा किछि नाही इम्प्लीमेंट ताले ही हैज टू कैरी आउट जदी हे गला त एकेटा ऑटोमेटिक विथड्रॉ करी
ओवर काई करिवा डायरेक्शन दे दो इफ देयर इज नो लॉफुल इम्प्लीमेंट इट मे बी व्हाट
16 मार्च ले हिची
repentation was also pending before the
forget about repentation once there is a judicial pronouncement it has to be worked out
but it was not been carried by the Tahsildar, your lordship.
Okay, that's right.
This order is passed only on 16th of March.
Fair court karo lekha through the
and the OP number 6 has tried to
the
dispose
order
of the
3 yeah and order at annexure 3 it is alleged in spite of a clear direction of the appellate authority for reverting back the land involving mutation case number kete okay 517 of 19
yes your lordship
517 of 19 The Tahsildar is still sitting over the matter. And there is unnecessary harassment to the petitioner in approaching here and there, considering serious allegation. Requisition stand disposed, however, directing the Tahsildar Patna. In the event there is no lawful obstruction in working out, the order dated 14/3/23 passed by the Sub-Collector Council by Annexure 3 that should be worked out. Such direction should be worked out at least within a period of 1 month, with providing of the corrected record of right to the petitioner within further 1 week. ଏଗୁଡାକରେ ଆପଣମାନେ କେହି ଦେଖୁନାହାନ୍ତି, there is already a statute from state statute of course from 2012. ଏଗୁଡା workout ନହେଲେ public authority ବିରୁଦ୍ଧରେ ପ୍ରତ୍ୟେକ ଦିନ 250 ଟଙ୍କା ଫାଇନ ହବ, କେହି ଦେଖୁନାହାନ୍ତି।
Odisha Public Services Act 2012.
Yes, ଆସିଛି, ସେଟା ଲେଖା ହେଇଛି completely. If a direction is given 2 months, 1 month, it is all right. ନହେଲେ ବି reasonable period. ନହେଲେ each day of delay ପାଇଁ ସେ ତହସିଲଦାର ଟା ଦବ 250 ଟଙ୍କା ଆପଣଙ୍କୁ ଦବ, କେହି ସେ ଆକ୍ଟ ଟାକୁ ପଢୁନାହାନ୍ତି। ଏଇଟା ଗୋଟେ ଦରଖାସ୍ତ ସବ୍ କଲେକ୍ଟର ଆଦାୟ କର ମତେ ଦିଅ, ଗଲା ଦେଖିବା କେମିତି ନ କରିବ ଆପଣ ଘରେ ନେଇ ପଟା ଦେଇ ଆସିବ। ଆଜି ଯାଇ ଖୋଜନ୍ତୁ ସେ ଆକ୍ଟ ଟାକୁ, ହେଲା ଖୋଜିବେ ଏବଂ 15 ଓକିଲ ଫ୍ରେଣ୍ଡ କୁ କହିବେ ସେ ଆକ୍ଟ ବିଷୟରେ, ହେଲା।
Item 21.
21 is
Same.
same, Lord.
Same. 14 ରେ ହେଇଛି order ଟା।
ଦେଖନ୍ତୁ ଦିଟା litigation ମୁଁ ଆଜି ସକାଳୁ ଦେଖୁଛି, ଏଇଥିରେ ମୁଁ ବସିଛି।
Item 22.
My lord, I am for the petitioner. Item 22.
Yes.
My lord, when prayer is repeated to direct collector Noyagarh for disposal of grievance petition pending dated 13/2/23.
Grievance କଣ କରୁଛନ୍ତି?
ଗୋଚର ଲ୍ୟାଣ୍ଡ କୁ ସେ ନେଇଯିବେ ବୋଲି ବସିଛନ୍ତି, କଲେକ୍ଟରଙ୍କୁ କୁହାଯାଇଛି ଯେ ତମେ ୟୁର ଏଜେନ୍ସିରେ ରିକଭରି କରାଯାଉ।
ଆପଣ କିଏ ଆପଣ ଭିଲେଜର? ଆପଣ କେତେଟା ଗାଈ ଲେଖିଛନ୍ତି ଦେଖିଲେ? କେତେଟା ଗାଈ ଅଛି ଆପଣଙ୍କର? ଆପଣ ଜମା ଗାଈ ନାହିଁ। So ଗୋଚର ଲ୍ୟାଣ୍ଡ ରହିଲା ଭାସିଗଲା, ଆପଣଙ୍କର କଣ ଯାଉଛି?
ଭିଲେଜର ସାର୍ ୟୁଜିଂ ଦି ଲ୍ୟାଣ୍ଡ।
ଆରେ ଭିଲେଜର ସାର୍ ୟୁଜିଂ, ଆପଣ କଣ ସରପଞ୍ଚ?
Alienating and recording the land.
କୋଉଠି ଭିଲେଜର ଆପଣଙ୍କୁ ଅଥରାଇଜେସନ କରିଛନ୍ତି?
No, my lord, no authorization.
କିଛି ନାହିଁ, ଆଉ ଆପଣ କାହିଁକି ଆସିଲେ?
My lord, କଲେକ୍ଟରଙ୍କୁ ଦେଇଛୁ ଆମେ ଗ୍ରିଭାନ୍ସ ଟା ଯେ
grievance this court without expression of any opinion. But be careful when you write, when you allege involving a gochar land, you must have a foundation. Villager ଦେଇଛନ୍ତି, no doubt. Villager ଦେଇଛନ୍ତି, villager କୋଉଠି ଲେଖିଲେ ଆପଣ? ତା ଭିତରେ one of the villager, ଆପଣଙ୍କର ଗାଈ କଥା କୋଉଠି ଲେଖିଲେ ଆପଣ? Considering representation pending before OP number 2, directed to dispose the representation in accordance with law, also in the involvement of the party likely to be affected within 3 months of the date of communication. The liquid advocate on VC from Puri. Yes.
Item 23.
Yes, 23.
May I please reverse? And that here in the instant case, my lord, the petitioner.
ଶୁଭୁନି, ମାଇକ କୁ ତଳକୁ ନିଅନ୍ତୁ, ନହେଲେ ଆପଣ ଉପରକୁ ଉଠନ୍ତୁ।
Petitioner is challenging the illegal selection of the opposite party number 3, my lord. But what happened, my lord, he has found selected. Found the application was floated by this departmental authorities, opposite party number 1 and 2. For opening up a retail outlet, selection of petrol.
Out a read pending achi.
That read petition has been issued notice to the opposite parties, directing to file their counter.
response to this writ
Right,
application.
then that is also involving same cause of action.
Same cause of action, but the subsequent development is Millard.
Subsequent development ହେଲେ ସେଥିରେ amendment ଆଣନ୍ତୁ ଆଉ ଗୋଟେ ରିଟ୍ କାଇଁ ଫାଇଲ କରୁଛନ୍ତି?
Fresh cause of action আসছে সেটা উঠুনি।
ତାହେଲେ ସେଇଟା withdraw করলে এটা ନେବି।
সেটা withdraw ମୁଁ କରିଦେବି।
ସେଟା withdraw ଦିଅନ୍ତୁ memo।
Yes, yes.
Yes, memo ଦିଅନ୍ତୁ କାଲିକି ଆସିବ matter ସେ file ସାଙ୍ଗରେ। You can't maintain two writ petitions. Yes. Place this matter tomorrow along with memo for withdrawing the WPC 13929 of 22. Yes, କାଲିକି ନିଆହବ memo file କରନ୍ତୁ ଆପଣ। Yes.
24 ଟା submit।
Sorry, yes, right.
Item 25.
Only election dispute.
Yes, my lord. That amendment petition at the instance of the defeated candidate.
Amendment has been allowed.
Yes, yes, after 5 months, my lord.
After 5 months?
Yes.
What is the nature of amendment?
Nature, that is the crux of the matter in the election dispute that regarding begotten of third child after the cutoff date, my lord. Begotten of third child after the cutoff date.
No, that is the dispute.
Yes. At
proposed amendment,
proposed amendment, whatever stated in the election petition as regard to date of birth and name, my lord, that has been entirely changed in the amendment.
Entirely changed?
Yes.
It after post written statement?
Yes, yes, yes.
Your written statement brought the corrected dates?
No, I have never raised such ground because I have never no third child, my lord.
Oh, you have disputed?
Yes, yes.
So this is an outcome of the response written
Yes.
statement. Notice further, there shall be stay of further proceeding. Election petition 1/22. Requisites as undertaken by day after tomorrow.
Obliged.
Yes.
Item 26.
So we have Mr. adjourned to next week.
Adjourn to next week.
Yes, ma'am.
26 already complied with.
A kind of yes. Submission at the instance of contempt by Sri Ponda that there has been already.
I don't have any instruction regarding that, whether it has been complied or
Prisoner
not.
submits, counsel for prisoner submits, he has no instruction from party. Now communicate kar diyantu ela for the filing of the working out direction. With service of copy on the learned counsel for the prisoner, this court find no purpose in keeping contempt application pending any further, which is disposed accordingly. Yes.
ଏଥିରେ ବି ଆଜ୍ଞା ଅର୍ଡର ହଉଛି 2020 କଣ୍ଟେଣ୍ଟ ଫାଇଲ 2023 ରେ କମ୍ପ୍ଲାଇ ହେଇଗଲା।
ମୋ ଓକିଲର ପଇସା ଗଜ ଗଜ ହଉଛି ସେ କଣ କରିବେ? ପୁରା
Item
ଓକିଲଙ୍କର-
27.
27 my lord already complied.
No, no, there is no complaint.
Complied ବା no
ଦିଅନ୍ତୁ ତାଙ୍କୁ ଦିଅନ୍ତୁ, ସିଏ ଜାଣିନି ନା ଆପଣ ବର୍ତ୍ତମାନ ଦଉଛନ୍ତି। କଣ ଡାଇରେକ୍ସନ ଥିଲା? Petition ରେ କଣ direction ଥିଲା?
page 8.
ପଢନ୍ତୁ, date କେତେ ଡାଇରେକ୍ସନ ର?
Order dated 17/1/2023.
ପଢନ୍ତୁ order ଟା considering the
Considering
imposed prayer.
it in disposal of the writ petition, this court observes in the event there is no challenge to the direction in annexure 6, the Tahsildar body is directed to work out the same by giving
Okay,
effect.
now what is the working out, Mr. Ponda?
Your lordship may kindly see.
The proceeding is already disposed.
Yes, disposed of.
Your lordship may kindly see the last page.
Your
of
lordship
complaint. They are saying that in another case, a dispute is pending. That's why it is kept pending. Then,
Okay, then that's a reasonable order.
That is pending before the division bench.
Yes.
but there is no stay order. Agent could have-
Sorry. You go and appear in the division bench and get the order vacated.
No, there is no stay, my lord. There is no stay. Even notice has not been issued.
Writ appeal ରେ notice ବି ହେଇନି?
No, not writ appeal, my lord. That is a WPC. WPC.
ଏ WPC ଟା single bench ରେ ଅଛି?
Division bench ରେ.
Preferred by another person and referring to that writ
Same
petition-
land involved? Same land?
Same.
ତାହେଲେ withdraw କରନ୍ତୁ ନହେଲେ dismiss କରିବି।
Not only that, my lord, another Proceeding under section 41 of OHJ Act also
Yes,
pending.
Learned counsel, you can go and appear in the division bench matter and get your order. Can't be complied in your favor. Either you wait or you go and get that order vacated or they get that petition dismissed.
I may permitted to order and with liberty, but my submission is Miller, in that writ petition, the other person, another person has filed that involving same issue also, but in that case, even Miller notice has not been issued. So far my knowledge is concerned.
Place this matter day after tomorrow, along with WPC 1004 of 2023.
No, that is my case. That is WPC number 8284.
8284.
Sorry,
8224 of 2023.
Yes.
8224 of 2022. As to day after tomorrow, देखिए, they stay in it, then they may be wrong. In the meantime, document claiming to be partial compliance of the direction of this court, and also indicating therein that there is lawful obstruction in proceeding with the matter. Keeping this in view, this court direct the posting of the matter to day after tomorrow along with so. तार बाहर करी आनिबे से कंप्यूटर शीट नहीं आसबे कोन पोजीशन अछि. Yes, next.
Item 28.
Connected to item 27.
ताले एटा भी से दिन आसीबो.
28 the order of this.
कि अछंती 28 रे कि अछंती आपण को केस. Yes, all right, देखो.
For orders item 29.
My lord, I am one of VC.
Yes.
My lord, I am for the petitioner. During the
2002 matter,
sir, pendency locomotive substitution steps niyayichi. Now the petitioner is also dead, and steps has been taken on 2020. IA number 12,000 of 71 of 2020. That has not come, but your lordship may look at the noting. So far, opposite party number 1 and 3.
He is received.
My lord.
Okay, valid service ହେଇଗଲା ତ ଠିକ ଅଛି କରୁନାହାନ୍ତି.
କେବଳ ଜଣଙ୍କ ଉପରେ ସେ କହୁଛନ୍ତି unclaimed ବୋଲି. ତା ମଝିରେ ଗୋଟେ noting ଅଛି unclaimed ବୋଲି.
They are all relations.
Yes.
Then argue.
My lord, so far petitioner is concerned that miscase your lordship may. I have independently filed this miscase along with Wakalatnama.
Petitioner has also died in the meantime.
Yeah, my lord, during COVID period. October 2000.
What is the miscase number?
12071 of 2020.
12071 of 20. Okay.
Within time, petitioner substitution within time filing Wakalatnama.
There is filing of substitution application in respect of sole petitioner by the miscase IA number 12071 of 20. Registry directed to place the matter along with the IA day after tomorrow.
My name, my appearance, these are all old. So fresh application and fresh Wakalatnama was also filed.
So na list ଅଛି ଆପଣଙ୍କ ନା
ତାଙ୍କ ସାଙ୍ଗରେ ଥିଲା ଅଫିସ ରେ ଥିଲା ବେଳେ ମୁଁ
ସେଟା ଆସୁ ସେ ପିଟିସନ ଭୋକଲାତନାମା ଆସୁ ଆଗ
ଆଜ୍ଞା
nothing on record.
My lord.
Yes, 30.
Item 30.
May I please? During pendency of the writ petition, my lord, the petitioner 2 as well as defendants 2 to 3 defendants have died, my lord.
Pardon?
During pendency of the writ petition, my lord, the petitioner 2 as well as opposite partner 2 and 6, they have died. I filed this application for substitution of the legal heirs, my lord.
Petitioner substitution co-application.
That is
Petitioner
21
two.
application.
Petitioner 2 ର substitution ଟା କୋ application
9965 of 2021.
9965
My lord.
ତାର କଣ legal heir କେହି ନାହାନ୍ତି?
ଜଣେ ଅଛନ୍ତି 2A schedule A ର 2A
କାଇଁ ଭୋକାଲତ ନାମ କାଇଁ?
ନାଇଁ ସେମାନେ ଆସୁନାହାନ୍ତି ବୋଲି ଆମେ କରିଛୁ ସେ ଆସୁନାହିଁ ତାଙ୍କ
ସେ ଆସୁନାହାନ୍ତି ଯଦି substitute କେମିତି ହବ?
ସେ ତ ନିଜେ ଆସିନି ବୋଲି ଆମେ ବାଧ୍ୟ ହେଇଛୁ
Substitution କେମିତି ହବ?
other we are
And if you take them to be to the side of pro forma opposite party, then your case goes.
yes they are selling along with us.
So find out the option.
Yes, I will pursue that to so far as 2A is concerned, I will pursue that option, Lord.
Huh?
I will pursue that option to bring her.
What option you will pursue?
Well, to bring to file Bakla now for her behalf, my lord.
Yeah, how long this will be dragged on? This is a case of 2004.
My lord.
Case of 2004.
Other defendants are have died, opposite parties have died.
You have lost in all forums.
Lord?
You have lost in all forums.
No,
Consolidation matter, you have lost in all forums.
consolidation
How
matter.
long you will drag on this?
Let's
Yes, there is
Open
no
up.
proper steps in the substitution of petitioner number 2. Petitioner is permitted to bring vokalatnama of the LRs of petitioner number 2.
One LR, that is somewhere.
Petitioner number
2A only. That is one LR. She has
2A.
2A.
2A. No, এটা substitution କାହାର କରିଛନ୍ତି ଆପଣ? Substitution of
2 as well as opposite number 6.
2 ରେ କଲେ ଖାଲି ଜଣେ ଅଛି ତାର?
ଆଜ୍ଞା ଜଣେ ଅଛି।
2A B ଦି ଜଣ ଲେଖା ହଉଛି ପରା?
ନାଇଁ 2A schedule A, you will find schedule A at 2A only. Shama Behara.
ପୀତାମ୍ବର.
ନାଇଁ son of late Giridhari Bharat.
Oh,
Your lordship will-
sorry.
Kindness.
Petitioner 2A.
My lord.
Okay, of the petitioner 2A, at least within 7 days. Failure of which the writ petition shall stand dismissed as a whole, as there is no possibility of hearing on the question involved in absence of the part of the aggrieved persons. You take steps, otherwise it will be dismissed. You should have filed the application along with Miss Case.
No, that should be, my lord, because he could not cooperate, just I have to.
Okay, you are provided 7 days. Do whatever you want to do.
My lord.
Yes.
Item 31.
Without reference to bench, will be dismissed without reference to bench. Yes, 31.
Dismiss for default.
Dismiss for default at what stage? Fresh admission stage?
Yes, Lord.
Okay. Considering the writ petition was dismissed for default at admission stage. In the meantime, you have soft copy of the writ petition on the other side.
Yes.
Okay, the writ petition, the CMAPL stand allowed and allowed in the restoration of the WPC 32217 of 22. What is this writ petition?
The writ petition is about, my lord, the one property of the petitioner name will by register by execution of will. Petitioner's name has been.
That's right. You are challenging a mutation order.
Mutation order, my lord.
So,
The
mutation
Tahsildar
order,
said
how?
rejected my application on the ground. It requires a probate proceeding because it is a princely state.
It requires
probate proceeding. my lord.
probate of the will.
Yes, sir, probate of the will.
Oh, you belong to which place?
Kalahandi, my lord.
Kalahandi?
Yes, my lord.
Kalahandi already covered.
Kalahandi covered.
Kali judgment ଆଣନ୍ତୁ.
Yes.
କାଲି କଳାହାଣ୍ଡିର judgment ଆଣନ୍ତୁ.
ଆଜ୍ଞା
ହେଲା place this matter day after tomorrow. Writ petition ଟା day after tomorrow ଆଣନ୍ତୁ judgment ଆଣନ୍ତୁ. ବରଗଡ଼, ସମ୍ବଲପୁର, କଳାହାଣ୍ଡି, ଦେଓଗଡ଼ ଏ ସବୁ ସରିଗଲାଣି ଖେଳ. ହେଲା ଯେତେ ଗଡଜାତ ମୁଁ ଗୋଟେ judgment ରେ କୋଉ ଏରିଆ ପାଇଁ will ଦରକାର ନାହିଁ ଗୋଟେ judgment ରେ ସବୁ ଏରିଆ ନାଁ ବି ଲେଖି ଦେଇଛି. Hon'Ble is also there. Talcher, Hon'Ble, Deogarh, Bargarh, Jharsuguda.
Administration of Odisha order 1948.
ତା ଦେହରେ ଲେଖା ହେଇଛି
ଲେଖା ହେଇଛି ମିଲord
Judgment ଆଣନ୍ତୁ।
ଭବାନୀ ପଟନା ମାନେ ଭବାନୀ ପଟନା and କଳାହାଣ୍ଡି
ଜଜମେଣ୍ଟ ଆଣନ୍ତୁ। ମୋର ଜଜମେଣ୍ଟ ରେ ମୁଁ ଡିଲ୍ କରିଛି ସବୁ ଜିନିଷ।
yes
ଆସୁ ଦେଖିବା ସେ ତାଙ୍କ ରିପିଟିସନ ନଥିବ।
ILR ରେ ରିପୋର୍ଟେଡ ହେଇଛି।
ILR
Item 32.
Yes, what is this a disposed repetition or pending?
And it's pending, my lord. My lord has been pleased to admit and issue notice to the.
Notice issue ହେଇଛି।
Yes, my lord.
Then why miscase is
Agency,
coming?
my lord, that I have taken the rent from my landlord for the opening of nursing home prior to my.
1 minute, flag A miscase.
My lord.
What is the miscase prayer?
Miscase, my lord, provisional registration certificate pending disposal of the writ application. My lord, issuance of provisional registration certificate for opening of the nursing home pending disposal of the writ application, my lord. That is the
Writ petition involve what dispute?
dispute, my lord. The OSFC has objected that the land is below has been mortgaged. Basing upon the OSFC's clarification that has been objected under Annexure 16, my lord. The CDM has objected that your lordship may kindly see page 70 clarification.
Your main application also for grant of registration
Registration
certificate.
certificate. Grant of registration certificate.
So how can
My lord,
there be
the-
interim order of this nature?
My lord, on the
Unless the
contingency, my
matter
lord,
is hard.
that I have taken the rent since long.
Forget. Yes, why
And
why
they
are
are-
not filing counter?
Will file, madam.
You file immediately because he is in loss every day.
Yes, yes.
Every day my nursing home is also not operating, my lord. Instruments are now
That's
going to
right,
damage.
that's right, but there can't be interim order of this nature.
Can I
Yes,
pray-
come. Interim application
You lie over because
involves prayer. As that in the main writ application, as that in the writ application. As a consequence, this court find difficulty in granting interim order. In absence of final adjudication, State Council asks for 2 weeks time to file counter. Let the counter affidavit be filed within 2 weeks, rejoinder if any within 1 week. Place the matter in 2nd week after vacation kariyo.
Along with your lordship, say 21849 of 2022, similar matter is pending. Another matter, they have given the
ଆଗ
certificate.
ଏଇଟା ରେଗୁଲାର ହଉ ସେଇଟା ଧରନ୍ତୁ ଆଗ
given
ପଳେଇ
the
ଆସିବ ସରିଯିବ କାହିଁ ତା ସାଙ୍ଗେ ଲଗଉଛ।
Again, they have given
Yes,
the
ma'am.
certificate which is pending, my lord. Same dispute.
ରେଡିଓ ପ୍ଲିଡିଂ ରେଡି
I-
ହେଲା ପରେ କହିବେ
I-
ମଗେଇବେ।
I-
Yes.
For addition item 33.
Item 40 ଟା ସେ କହିଥିଲେ ମନେ ପକେଇବାକୁ ଦେ।
40 ଟା କାଲି ମୁଁ ରିକ୍ୱେଷ୍ଟ କରିବି କାଲିକା ପାଇଁ ମିଷ୍ଟର
କାଲି
ନାଇଁ ନାଇଁ ମିଷ୍ଟର
ପଡୁନି, sir.
ଆଇଟମ 40 କଥା କହୁଛି
33.
ହଁ 30
Item 33, who is there? Yes, none appears for the petitioner. Matter is pending since 98. This is for nobody showing interest.
Item 34.
And I am on VC Millers, may I please your lordship.
Yes.
This is my second journey for a identification. If your lordship will kindly turn to page 132.
In this
132.
case,
Pleading complete ହେଇନି Mr. Das.
Whereas counter stayed above. I can say.
ମାନେ ଆଉ ଗୋଟେ କଥା ଏଥିରେ ଆଉ ଗୋଟେ ଜିନିଷ ଅଛି ଆପଣ କାଇଣ୍ଡଲି ଦେଖନ୍ତୁ 115 କୁ ଆସନ୍ତୁ ପେଜ କୁ ଏ demarcation case involves Lord 2 sets of persons and there in the demarcation proceeding they have filed objection but they are not made parties.
ସିଏ complete କରିସାରନ୍ତୁ।
Well, Millers, they have filed objection. Your lordship kindly see. My friend is saying, your lordship, let me place the order then it will do. Hearing in the demarcation number is taken up today. Had both parties.
Just 1 minute, Mr. Das, page 100.
133 Millers.
133.
Sorry, 32.
132.
2.
Only 32.
132. I think it is the last
ଟିକେ ରୁହନ୍ତୁ ବୋଧେ I am holding a wrong brief.
one last page of the brief.
Sorry.
Earlier, I got a direction for demarcation from this honorable court. Hearing the demarcation case, it is taken up had parties petitioner represented by so and so, represented including so and so. The advocate for opposition party strongly objected demarcation plot number ete. Moja Tangaruda, he submits that he is in physical possession of the said property and also constructed boundary wall to 6 feet. Was taken up the land in question for demarcation is plot number ete. Moja Tangaruda Tahsildar has been partly transacted to one Ranjan Ponda. He has never appeared and objected to it. There is only an area of 60 decimals in the name of the petitioner. The ROR attached in the case record. I have also filed the ROR before this court. There is long pending litigation, right? There is no litigation. I have specifically avoided in the writ petition, there is no litigation to the knowledge of this petitioner. No notice has been served.
Yes, how
And
can
some
one, is there, okay, there is private party or?
Yes, private party. That is my submission. There has not been.
There's private parties. They are, just a minute, Mr. Ghosh, let me submit. Let the Tahsildar be directed to produce the case numbers or the opposite parties produce the case numbers.
That's a different issue. Mr. Das, if I am finally disposing, I must involve the party likely to be affected.
That's there, but there is no document. What can I do? Why should I involve?
Then who is objecting there?
They said some people came and objected.
No, on page 114, Dakuntu, Takuri brief 114. He has annexed that document. The objector is Vidyut Prabha Healthcare Private Limited. And it is represented by some Mahanti.
112.
114.
That objection they have filed before the Tahsildar.
And this
So
demarcation
you
case.
make it a party, Mr. Das.
Ranjan Kumar Panda is the demarcation applicant.
Listen, the merit of the case is something that can be considered. Your allegation may be appropriate, but the order should go in the involvement of the party likely to be affected.
All right,
Mr. Ghosh,
give
you
me-
also take instruction. Suppose there is no litigation as of now, then why you put a hand close?
No, litigation means
No, somebody dispute, then
There
you
is
have
no
to take it.
litigation.
No, they have referred to certain case numbers also in the objection.
Yes, I have
The
said,
order
Milord,
order
there
of
is
the
no
Tahsildar might not be clear, but in the
Just-
objection, I found number of cases have been referred to.
Then
Yeah,
find
yeah.
Yes.
Mr. Ghosh, Mr.
Taco
Ghosh,
property is their main party.
please hear me.
You bring a-
Page, your Lordship may see page 16 of my petition, para 27. It is humbly submitted in respect of the case and there is no litigation is pending to the knowledge of the petitioner.
No, but
before
their
any court
objection
of law.
at the same time, Mr. Das, their objection come to page 116.
Page 27 ने मैं कोई किसी नहीं
No, 115 रे civil suit ଗୋଟେ number mention ହେଇଛି. Then 116 रे ଗୋଟେ criminal case mention ହେଇଛି.
115, I don't.
Yes, 115. The objection page 2.
Where I am not a party, Milord.
No, you may not be, but suppose on that land there is a dispute pending. Therefore, you bring that party, I will hear all of you.
All right, I will implement all of them.
Yes. From the objection running page.
115.
Commencing at 114. Running page 115 and 16.
Milord, these documents I have filed in this case.
There
So
appears-
there was a arbitration proceeding.
There
The
appears-
arbitrator settled the.
there has been objection for the demarcation involved on the premises of pending litigation. Mr. Das.
This Milord Sahib, your Lordship, just hear me a second. These documents I have filed in the brief. Entire document. I have filed. There is no dispute with me. This is a case, Milord.
No,
My
that
mother-
Mr.
my
Das, Mr. Das, this is a different issue, whether those disputes involve you or not. But
No,
it
Milord.
may be an issue.
Your Lordship, give me 1 minute. A sample copy of the order passed in similar file.
Where are you reading?
Milord, the case law which has been the dispute case which para 115 in a civil suit filed by on my one Anusoyan on the basis of state panchayat award, the second additional sub-judge court was dismissed his came ultimately head Panchayat Award Faisala. Document is fraudulent one. Because I have not purchased from that.
So that is their objection, Mr. Das.
Their judgment copy I have filed, my lord.
Okay. All right. Therefore, let us get into the subject whole as a whole and give a direction so that it can be effective.
Because I have filed all the documents, your lordship may keep to one day I will point out one by document.
No, but I'll not dispose this in absence of the party likely to be affected. Because there is already an objector entered in the demarcation proceeding.
Because objector entering, but produce some document of title, na? Some document of title.
That you may be saying, let them come. Why are you presuming I will be rejecting? I may allow in your favor, but
No,
in the
I am not afraid of impleading any of them. But they should have produced a piece of paper before the Tahsildar.
No, at least they have indicated. Therefore, all right, if you say that you don't know who are the objectors.
I know, my lord, has named them.
So then bring them.
All right, I will bring them. Your lordship may give me 3 days time. Thereafter I will.
Kaun lekhila? Okay. Obstructing the undertaking of the demarcation exercise. This court finds there should not be final outcome in this proceeding in absence of such objector. Sri Das, learned senior counsel, undertakes to bring in the objector by filing appropriate application day after tomorrow. Place this matter day after tomorrow along with any application if you need.
Just 1 second. While the Tahsildar is saying there is objection, should we not ask them produce your documents?
Mr. Das, therefore I am involving them.
Obliged.
Therefore I am involving.
Obliged.
What was that material to obstruct the demarcation? Yes. I am conscious, Mr. Das, don't worry.
Obliged.
I have already put a question to State Council. You must gather from that.
Yeah, obliged.
Yes, you also bring your record in the meantime. Let us see what was that lawful obstructing.
Right.
Suppose there is no lawful obstruction, then you can very well seek police protection and get the measurement. Yes.
Item 35.
My lord, my lord, I am for the petitioner, my lord. Day before yesterday, I appeared for the opposite partner 7 and filed my counter affidavit. And state government has filed the counter affidavit, has not sought the copy of it.
Right now,
earlier they have filed the counter, but your lordship allowed the amendment to amend the court title, my lord. We agreed with he had approved by filing a writ appeal, and in that writ appeal was dismissed. And after dismissal of that writ appeal, my lord, again they are filing this counter.
I am filing
counter. You have been served with the copy of counter?
Yes, my lord.
All right. Are you ready to argue?
Yes, my lord.
My lord, state government filed the counter affidavit. Copy has not.
Yes, they didn't copy down.
Well, I am appearing for the Sarpanch, opposite part number 7, my lord.
Yes.
They are not, my lord.
7.
Six. They have not sought any copy.
I will serve a copy on him.
Counter sub diyantu.
They will copy.
Counter sub diyantu tapare
and I will file a rejoinder affidavit if it is required.
Okay, rejoinder ji jaha file kariye ta parantu first week after third week after vacation asibo. It appears pleading is yet to be completed.
Yes.
Though some of the opposite parties have already filed counter. Today in course of hearing, Sri Manoj Kumar Mahanti,
newly added opposite partner 7.
Advocate appearing for OP number 7 filed counter with extension of copy to this counsel for the petitioner, so also state को
petition Madam
Mahapatra कहाँ पे appear
करते I will give. I came to know.
आज्ञा सरपंच कौन तो नहीं OP कौन तो
OP number 6.
हाँ OP
I will serve a copy.
सरपंच रे मत कौन
I came to know today that
State Council appearing for 2 and 4 also files counter with exchange of copies on each of the opposite parties. डाकी सारे तापर कहले हबनी जेतक सरिलाणी सेतक आग डका ही जाऊ Is counsel appearing for the OP number 6? You have a contest in the proceeding? You have a contest in the proceeding?
Bond belong to the company.
Wants to bring a counter affidavit. Well, there is no completion of pleading. Let the counter affidavit of OP6 be brought within 2 weeks. Rejoinder, if any, by any of the interested parties be brought within 2 weeks. Place the matter in first week of June.
My lord, I also may be added as a party, my lord, because my application for intervention is pending.
I'll file the counter to that.
Your intervention will be considered when the matter will be taken up for hearing.
My lord.
My lord, one prayer.
My lord, I
How come prayer?
One prayer. Well, it is recorded that consolidated cost title has been served on me, my lord. That has not been served on me till today.
Yes, find out any difficulty
Consolidated
there.
cost title, let him serve on me, my lord.
All right, yes. ଦେଇ ଦିଅନ୍ତୁ କପି ସେଥିରେ କଣ ଅଛି କନସଲଟେଟେଡ ଗୋଟେ ବାଣ୍ଟି ଦେଲେ କଣ ଏତେ ସମୟ ମିଳିଲାଣି
ଆଉ ଗୋଟେ ମୁଁ ଦେଇଦଉଛି ଆପଣ
ନାଇଁ ତ ମୁଁ ଫାଇଲ
ଦିଅନ୍ତୁ ଦେଇକିରି ମେମୋ ଫାଇଲ କରିଦିଅନ୍ତୁ ନହେଲେ ରିସିପ୍ଟ ଅବଟେନ୍ କରନ୍ତୁ yes next
item 36
Entry model ଟା continue କରୁ। You must have granted an entry model.
ଆଜ୍ଞା ଟିକେ ମାଇକ ଆଗରେ କୁହନ୍ତୁ
There is an entry model passed by this honorable court, my lord.
entry model will continue automatically. Yes.
सरपंच हो कि जियो हो।
Yes, entry model to continue.
अरे entry model
petitioner को नहीं extension ପାଇଁ ଆପଣ
Yes,
କହୁଛନ୍ତି
yes, yes. Give place to 36.
May I please, your lordship? In this case, my lord.
Yes,
The
Mr.
petitioner
Satpathy, what is the urgency here?
Urgency, no, my
These
lord.
are all 22 matters.
My lord, the urgency is the violation of the fundamental right. The petitioner arbitrarily declared as a antisocial history by the police.
All right,
station.
all right. ଆପଣଙ୍କୁ ଇଏ କରିଦେଇଛନ୍ତି
And history sheet.
ଶୁଣାଣି ହବ ଠିକ ଅଛି second week of July.
I have filed the written note of submission today.
Yes,
And
written note of submission filed herein be kept on record.
And citation also.
Yes. Along with citations, right. Copy they each on the other side. Yeah, yes. Yes.
item 38 may I please, your lordship?
Yes, what urgency here?
Urgency is, my lord, the house possession is necessary to be delivered and the lease deed is to be recorded registered. The possession of the house, number HIG 6 Igenia phase 2 needs to be handed over the possession. And the
Counter file ହେଲାଣି କି?
Counter file is rejoinder will file.
But originality,
Rejoinder so file ହେଇଗଲାଣି.
yes, originality is not a party in this case. Originality, Harihar Sahu is not originality, Harihar Sahu is not party in this case.
That is up to him. If he is not making him, he may lose in the.
He is not necessary party because he has taken the money.
Therefore, can we compel him?
He is a necessary.
You raise you have your objection. You have raised that in your counter.
Yes, yes,
All right. Despite that, he says he is not a necessary party. So therefore, let us hear the matter in absence of him. It next week as well. Next week. Yes. Pleading complete is the written note of submission. धरकिरी आसिबे दी जन जाक होला सुनि दबा प्लीज.
Item 39
39 ଟା ଟିକେ next week ଆସୁ ଟିକେ 39 ଟା
next week
ନାଇଁ ନାଇଁ ସେ କଣ ହେଇଛି ସେ ଆରଥର ଯୋଉ ଫାଇଲ ଟା ଆସିଥିଲା ଆମର ସେ ଫାଇଲ ଗୁଡା ମିସପ୍ଲେସ
asking for time in this.
ନାଇଁ 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 always
Madam, you know that is a ground in writ appeal. ମୁଁ ସମୟ ମାଗିଲି ଦେଲେନି.
ଏଟା ଆଗେ contemporary.
ନାଇଁ ନାଇଁ ନାଇଁ
ये फाइल करी कंटेम्प्ट रीट अपील ले जाईची कंटेम्प्ट भी रीट अपील नहीं गलानी
ନାଇଁ ନାଇଁ ସେ ଇଏ ସେଟା କଣ କି ସେ ଆମ ଫାଇଲ ଟା ଟିକେ ଅଫିସ ରେ ମିସପ୍ଲେସ କରି ଦେଇଛନ୍ତି.
Contact 6 time you will get next week that is result.
ଏଟା କେତର time
ନା ଆମେ କାଇଁ ଟାଇମ
ନା
କିଏ ନଉଛି
ଆପଣ ଦଉଛନ୍ତି ସବୁ
ମୁଁ ତ କରେ ନେକ୍ସଟ ୱିକ୍ ଆଜ୍ଞା ଏଇ ମଙ୍ଗଳବାର
हाँ मंगलवार यही मंगलवार.
Item 40 टा So
Item
item 40 टा
40
काली असुका कि Mr. Sonok Mishra was holding this brief. Today he fell ill and he didn't turn up. So actually ମୁଁ prepared ହେଇନି ସେ କେସଟା joint inspection ଟା ହେଇଯାଇଛି।
ତିନିଥର time ନେଲେଣି ମୋର କିଛି
ନାଇଁ,
କହିବାର
ନାଇଁ,
ବଡ
joint inspection ହେଇଯାଇଛି, report ଆସିଯାଇଛି।
my
ସେ
difficulty.
କାଲିକି ଆସିଲେ ଆପଣ ଖାଲି joint inspection report ଟା ଦେଖିବେ ଯାହା କରିବା କଥା କରିବେ।
4 ମାସ ହେଲାଣି
ନାଇଁ କାଲି ମୁଁ ତ କହୁଛି କାଲି କଥା।
This matter will be taken up first case tomorrow after the fresh admission.
Yes.
ହେଲା ଏଇଟା ମନେ ପକେଇବ କାଲି।
ଆଜ୍ଞା ଆଜ୍ଞା
ଏଇଟା ସବୁଦିନ ଗଡୁଛି। ତେଣୁ yes tomorrow you ask Mr.
ଆଜ୍ଞା ଆଜ୍ଞା
Mishra to
ଆଜ୍ଞା।
be present here.
ତାପରେ ସେ ଆସିଯାଇଛି joint inspection report ଟା ବି place କରିବେ ସେ ତାଙ୍କ presence ରେ ହେଇଛି ସେ report ଟା ବି ଅଛି।
Complete all requirements.
ସେ ତା ଯାହା commission କରିବାକୁ ପଡିବ।
Joint inspection ର copy ଟେ ତାଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ।
ନାଇଁ ସେମାନେ ଥିଲେ ପରା ତାଙ୍କ
I am
presence
ପାଇଛନ୍ତି ତ?
party concern was present in the inspection. He is a signatory.
All right. ସମସ୍ତଙ୍କୁ କୁହାଯାଇଥିଲା ତ ଯିବା ପାଇଁ।
ଆଜ୍ଞା ଆଜ୍ଞା।
ସେ ସବୁ comply sir କର।
ଠିକ। ହଉନି ମାନେ ଆଉ 3.5 ପରେ ହିୟରିଂ କରିବ। And every day night ଘରେ ମତେ correction କରିବାକୁ ପଡୁଛି କିଛି pending judgment।
Totally blocked. ସବୁବେଳେ ତ ଆପଣ କୋର୍ଟ ଉପରେ ହିଁ ଡାକି ଦଉଛନ୍ତି।
ସକାଳୁ ବସୁଥିଲେ କଣ ହଉଥିଲା କି ହଁ ମୋର ଗୋଟାଏ ସୁଦ୍ଧା ସରି ଯାଉଥିଲା ଫ୍ରେଶ ଆଡମିସନ ଉପରବେଳାକୁ ମୁଁ ହିୟରିଂ 10ଟା କି 8ଟା।
ଡିଭିଜନ ବେଞ୍ଚ ବସିବା ଜଜମେଣ୍ଟ ଗୁଡା ଡାକି
ଡିଭିଜନ ବେଞ୍ଚ ରେ ବହୁତ କଣ୍ଟେଷ୍ଟିଂ ମ୍ୟାଟର ରହୁଛି। ଅବୁଝା ଓକିଲ ସବୁ ଅଛନ୍ତି ଡିଭିଜନ ବେଞ୍ଚ ରେ ପିଟିସନର ସାଇଡ ରୁ ମାରାତ୍ମକ ସବୁ। In absence of pleading argument ହବ, contrary to law argument ହବ, agreement ର relevance ଅଛି, agreement ଟା ଦିଆ ହେଇ ନଥିବ, stand ବି ନିଆ ହେଇ ନଥିବ, କୋଉଠି 90 କୋଟି ବାକି, କୋଉଠି 80 କୋଟି ବାକି, କୋଉଠି 100 କୋଟି ବାକି, କୋଉଠି 80 ଲକ୍ଷ ବାକି, ସେଟା ଦେଖା ହଉଛି annual loss, ସେଟା ଲୋଡ ହଉଛି consumer ର ଯୋଉ ହଉଛି revised tariff ଦେହରେ ଲୋଡ ହଉଛି। ପିକୁଲିଆ ଜିନିଷ ସବୁ ଆସୁଛି ବର୍ତ୍ତମାନ knowledge କୁ ଆସୁଛି। ଆଉ previous order sheet ହଉଛି 10ଟା adjournment, 12ଟା adjournment, 25ଟା adjournment, 30ଟା adjournment,